May I permitted I mention the matter
For inclusion,
application for substitution, my lord.
substitution before the register logima within time. Yes.
May I have your lordship kind if to mention for inclusion, lordship. It's a group.
Inclusion.
Yes.
Please wait for some time.
My lord,
Yes.
Petitioner is a senior citizen, my lord, and
Maybe please wait for some time
No,
because
my lord, it is in the list, my lord, 180 upgradation.
it is appearing in the list.
Yes,
What do you want?
upgradation, my lord.
No upgradation. Yes, call the list.
My lord, should you mention it is a restoration application.
When it was dismissed for default.
Time notice barred by. Within 1 month, I have filed.
No, when it was dismissed for default, what is the date of dismissal?
Date of dismissal, my lord. In the month of January.
January 2025. By which bench?
My lord.
By which bench?
Bench, my lord. Grateful, my lord.
Yes. You have sub notice upon the other side.
Lordship. I have served, my lord. Not
No
only,
hearing.
but also petition of
Yes.
Lordship.
All the matters.
Lordship.
My lord, the
Hearing.
no, my lord, the it is appearing in the list.
Yes.
But the upgradation, my lord, the petitioner is not getting pension. My lord, the
Upgradation hearing matter, it is problem.
this is not very simple, my lord. The
All matters are simple.
whatever, my lord, the admissible pension, let them release. This is my prayer, innocuous prayer.
Yes, call the
Lordship. May be permitted to mention regarding item number 9 of today's list,
What
Lordship.
do you want?
Lordship, I want a week time, Lordship, because
Let it be called on. Yes.
as well, Lordship.
Lordship, in this matter, Mr. Pulokas Baswai will appear behalf of the respondent due to his physical illness. He couldn't come to the court.
Item number 9.
Yes, yes.
You are appearing in item number 9.
For respondent.
Chaudhary,
Yes, Lordship.
your matter has been called on. You are in item number 9.
Yes,
Your
Lordship.
matter has been called on.
Lordship.
Yes, what do you want?
Lordship, I need just 1 week time, Lordship, because it is a review of an order passed by your Lordship. And
This is an application for review.
review, Lordship.
So this is not review, but appeal in disguise.
But
Appeal in disguise. Because the points raised, your lordship's pleasure was to deal with all these issues in the order. And they should establish at least that the error apparent on the face of it. Where is that? They only-
Lordship, that's why I'm saying just give me 7 days time, Lordship. I'll satisfy your Lordship.
you are for the petitioner.
Petitioner.
You appeared in the writ petition.
No.
So come with that judgment where the Honorable Supreme Court deprecated the practice of moving a review by change of advocate. Come ready with that judgment
No,
and be ready with the consequences.
Lordship, I'll.
And that was a long time back. So multiplying with the price index.
Lordship.
Not today. Yes, next.
Lordship, next week, Lordship.
And not to
Oh.
Today is next week.
Yes.
All right,
Oh,
not
ah.
this week. Kore din.
Great.
Yes, next.
14.
But this is that Partho Go matter. They are not complying with your lordship's order, specific directions to release money.
My lord, Mr. Shayan Sinha is appearing in this matter. My lord, he's terribly ill and he has been advised to take bed rest.
Please use the microphone.
Sorry. My lord, Mr. Shayan Sinha is appearing in this matter for Bonga municipality. My lord, he's terribly ill. He's actually having a hemorrhage from his nose. So he has been
He's
advised.
ill.
Yes, he's
I
terribly
will
ill.
not
my lord.
stand in the. They have to, your lordship had passed the order directive money on the basis of.
All right, I'm making it not today because there is also a resolution.
No, affidavit filed by a superintendent engineer, they admitted. Now they have filed a vacating application relying on an affidavit affirmed by sub-assistant engineer. Your lordship said you cannot now change the case.
All right, let Mr. Sinha.
Very well.
Yes, call the next matter.
Deeply obliged, my lord.
Not today.
Not today.
Very well. Then let it retain its position.
Will return its position. Yes.
15 and 16.
15, 16, I beg to appear on behalf of the petitioner, my lord.
Yes.
My lord, may I just first indicate the facts in short? My lord, March 2020,
Who is opposing you?
my lord, Sudhir Senapati is for the bank and one Arnob Dotto is for the private respondent. They appeared on the last occasion. May I just indicate the facts? No, there will be no occasion to pass any order today.
Then what will be the use, Mr. Chakravarti?
My lord, may
What will be the use? Your point is that in the report of the ICC, it has been held that the allegations have not been proved. Even then, a recommendation has
Another
been made.
point,
A disciplinary
my lord,
authority.
while I was going through the writ petition, I find that the complaint on the basis of which all this happened, I was not named in it.
All right. Not today.
Yes, ma'am. My lord, it should, I believe it should retain its position. My 15 to 18 then.
15 to
15, 16,
18,
17.
not today. Next.
এরপরে না না আমাদের কিছু নেই
19.
19, my lord, Mr. Oyam Banerjee is appearing for the petitioner, my lord. Oyam Banerjee, Mr.
Yes.
My lord, he could not come to court today, my lord. I'm only praying for not
Yeah.
today. My lord, I'm not on record, lordship. Otherwise, I would have assisted, my lord.
You are not the advocate on record.
No, my lord.
You are his chamber junior.
I am, my lord.
All right, not today.
I'm deeply obliged, my lord.
Twenty
for the respondent school lordship, that is the private school, that matter, maintainability.
Sukanta Chakravarti, where is he?
Here, I don't know, lordship, paragraph number 13 of your lordship judge, 33 of your lordship judgment, that is the issue.
Not today, next.
21.
Item number 21, I'm led by Mr. Shokinath Mukherjee. He's appearing on.
Yes, Mr. Mukherjee.
I beg to appear, my lord, on behalf of the petitioner.
Yes.
My lord, I
Appealing for the respondent.
Respondent number 10, my lord. I'm praying for only not today, my lord.
Not today.
Ratnanko Banerjee is not.
Who is the answering respondent? State.
10.
Mr. Mahato.
Mr. Lalit
Mahato is
Mahato.
appearing. What you doing, my lord?
Mr. Mukherjee, the state is not represented. There is also a resolution today. Resolution taken by the Bar Association.
My lord, except on Monday, kindly keep it on any other day. My clerk is going to Kumbh.
But, it is a very good ground. Mr. Mukherjee, Lanet, senior advocate, appears for the petitioner. An accommodation has been paid for by the learned advocate appearing for the 10th respondent. 10th respondent. Full stop. None appears for the state. Full stop. For the ends of justice, list this matter. The hearing of the matter stands adjourned for the day. Oh, you want it on Tuesday?
Only not Monday. Any day.
Also, for the ends of justice, list this matter on Mongolbar date diye din. February 18, 2025.
Grateful, lordship.
18, Mr. Mukherjee. 18th of February.
Yes,
Tuesday.
yes, 18. Whatever suits your lordship, my lord, except Monday.
Your Lordship, I appeal for respondent number 10 in this matter. Your Lordship, sorry, I had to join late because of some technical problem, Your Lordship, in the internet.
Yes.
Your Lordship, I am otherwise ready in this matter. If Mr. Learned Senior, Mr. Mukherjee wants to proceed, Your Lordship, I have no.
State is not here. State is the answering
It is
respondent.
not. Your Lordship, only one thing I wanted to apprise this court. Perhaps Mr. Mukherjee has also the entire acquisition process has been held to be bad.
Yes.
The entire acquisition process held, but nothing remains further in the writ petition.
So
Because
now
I
you
have
are
also got the money back from the state.
So you are also accepting the argument of Mr. Mukherjee.
No, I just wanted to apprise this court that there are judgments where the entire acquisition process has been held to be bad.
All right. All right.
The Lordship will take up this matter on. Your Lordship has fixed it.
18th.
18th.
Tuesday.
Tuesday. Grateful.
Yes, next.
22,
22, I beg to appear on behalf of the petitioner. My lord, this is that airport authority matter wherein Mr. Muzumdar was arguing.
Where is Mr. Mukherjee? Can you start? Because today you have got a date.
My lord, Mr. Muzumdar will argue. Can it be on Passover? Can it be at 2 p.m.? Because Mr. Muzumdar was continuing the argument.
You can start. Mr. Mojumdar will join you. Where is your other side? But the Salam, has she come? She has not come. There is a resolution also. Not today. Next.
Monday.
Your Lordship, perhaps in item number 21, your Lordship has recorded that nobody appeared for the respondent number 10. Your Lordship, I appeared, Audit Banerjee.
All right. তাহলে ওটাকে করে দিন যে the petitioner আর হচ্ছে respondent number 10 is present. None appears for the state.
I am grateful, Your Lordship. Extremely grateful. Extremely grateful.
Yes.
23,
So I appear for the petitioner. So it is that matter, Mr. Mokaram Hussain appeared in a service matter. The disciplinary authority
Today.
cannot
Today,
insist,
in
your
his
lordship.
absence, it cannot be
Yes.
taken up.
Kindly make it not today, Monday.
Not today. Yes.
Yet.
24,
Here for the
I'm for the
KMD,
petitioner.
respondent KMD. KMD, respondent KMD, Lordship.
Yes.
Led by Mr. Sukhdeep.
I am led by Mr. Haradhan Banerjee.
You are led by.
Haradhan Banerjee.
You can start.
I can start.
Because the respondent is also here.
My lord, I'm praying one thing, my lord. Then if they start, my lord, Mr. Talukdar is engaged in another court, my lord. Kindly make it not today.
Not today. Next.
26,
I appear on behalf of the petitioner. My lord, that is
Last day. Increment. You retired on a day prior to the
Yes,
last date of increment.
yes, the first of the case in Kolkata.
Matter is pending before
Today,
you.
today it will, there is no stay. My lord, today all the analogous some issues has cropped out that will when the date of the benefits will be paid. So regarding that, a review was filed, that review is pending and all matters has been analogous to be heard today.
So I'm making it not today or
Not today, not today.
not today.
Not today.
All it's not today.
Because there is no stay. I have checked from the
Maybe there is no
No,
stay,
no, my
but
lord, my
since
lord.
the issue is pending before
Yes,
the
ma'am.
House of
Yes, ma'am. Yes, ma'am. And if I get the order, it will be more convenient.
Even
for
though technically you may be right in saying that you can proceed, but
No, no, no,
since
my
the
lord, I'm
issue
not
is
proceeding.
pending,
No, 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 I'm not proceeding, my lord. Let it be.
yes, not today. Next.
Not today, not today.
7,
Today. Not today.
My lord, 27, Mr. Shoptangshu Basu is appearing for the petitioner number
Yes.
1. He could not come to court, my lord, due to his
Basu has not
personal-
come.
No.
Mr. Basu has not come, my lord. I'm assisting Mr. Basu, my lord. But since he's absent,
Energy, your matter was adjourned. Now you are appearing after it has been adjourned.
I could not attend court, my lord, for some reason, my lord.
Yes.
Kindly,
Because
my lord,
start
accept-
Mr. Banerjee. Mr. Basu will join you.
my lord, it's a voluminous matter, my lord. Mr. Basu will not join because today he's not in a position to argue. That is why I'm praying, Lord, it's a land acquisition matter, my lord. We have challenged the acquisition on the ground that not there's no acquisition in the eye of law. And
Who is appearing for the state?
Mr. Lolit Mohan Mahathir for the state and Mr.
And the
Abhutosh
requiring
Majumdar.
body?
Mr. Abhutosh Majumdar is for the requiring body.
All right, not today. Next.
My lord.
28,
Here for respondent KMD, Lordship.
Not today. Next.
29,
Lordship, Mrs. Chandrayalam is appearing on behalf of the respondent.
What do you want?
She is not well, praying for not today.
Not today. Next.
30,
30, my lord, in this matter, I am appealing for the petitioner.
Who is opposing you, Mr. Rai?
My lord, I am on behalf of the respondent, state respondent.
Private respondent or the
State respondent.
state respondent? All right. Any private respondent, Mr. Rai?
Challenging the acquisition proceedings of the
Requiring body?
private respondent?
Oh,
Oh,
state.
my lord, I appear.
You are for the state. You are
I am for the Bardhaman Development Authority, BDA.
requiring body.
Yes. My lord,
All
Cali-
parties are now present.
no, my lord, Mr. Arindam Banerjee is appearing on this matter. Kindly not today.
Why? Where is he? Din.
অ্যাপ্লিকেশন কি আছে অ্যাপ্লিকেশন কিছু আছে নাকি
Application কিছু আছে?
Yes, we have filed one can
for what?
non-maintainability of this writ.
Not maintainability of the writ petition.
The copy,
You want
let
to
a
raise-
copy of this.
I'm serving the copy.
You want to raise your point first, or you will raise after if Mr. Rai makes his submission. Choice is yours.
The copy.
You want to raise your maintainability now or after Mr. Rai makes his submission?
My lord, my submission is that I have filed this can. Now I am serving the copy to the other side. If they file any opposition against this can, they can kindly fix it up for a hearing.
Not necessary. Yes, Mr. Rai. What is the point of your maintainability?
Whether this acquisition was at the behest of the public purpose or for a company.
All right. I will allow you to raise your point. Yes. Yes, Mr. Rai.
Huh? Just শুনছেন তো। Now, this is relating to the acquisition proceedings which is initiated for the purpose of Bardhaman Sachi project. My lord will find this is the subject matter of challenge. Initially, this was started in the year 2000.
Why did I hear?
That I have to check up. Any of the parties or not. That I have to check up. না না যদি হয় তাহলে জিজ্ঞেস করে নাও যদি কিছু থাকে কেউ come back on Monday my lord, then my lord I have to
Let me check up from the records.
from the records my lord will not find otherwise my lord I
Records there is then
but any of the parties my lord Sachi is there media is there and the state and the for the private respondent private.
This is the writ petition of October 2019.
2019. That is after.
All right.
From here to there.
Yes.
হ্যাঁ সময় আছে। Now 2005 my lord this process the initial notification.
Yes, what happened? Any difficulty, Mr. Rai?
কিছু বলছেন কি?
Yes, any difficulty?
But 2005, 2006, these notifications were issued under Section 4 for the purpose of acquisition of a large
Act 1.
Act 1. This is under Act 1. Where it was held that this property is going to be used for the purpose of housing project, for accommodation of all the poor sector, for the and for land township project, this will be done at the behest of the government. The money is the public money and for public purpose. That was the sum and substance of the notification. Initially, it was challenged by some of the parties on the ground that no, though it was mentioned as a public purpose, but it's for the benefit of the private organization. That was a subject matter of challenge and came before this honorable court. That is why your lordship can turn to the order passed.
What happened? What was held?
The stand taken by the state because it's different. Page, my lord, can you turn to page? No. যত বিশ্বাস সাহেবের অর্ডারটা You will also turn to page 104.
104.
Yes. Everything it starts on 104. If you also turn to page 108.
Yes.
This is the initial round of litigation for the part challenging this acquisition process. But I read out it in stated because it requires consideration. The first petition suing its own name in a society registered on 17th.
Which page you are placing?
Page 108.
Yes.
My lord, find from the first petitioner, my lord.
Yes, yes.
In his own name is a society registered on January such and such and the West Bengal Society Registration Act. The second and third petitions are the president and secretary respectively of the society. They all claim that they have taken out the writ petition for espousing the cause of their 197 members was agreed by the 12 section 4 notification published on different dates. Initiating proceedings for acquisition of lands, including the lands under the provision of Land Acquisition Act 1894. The second and third petitioner filed an objection under section 5A dated such and such. They submitted an additional objection dated such and such. A group of 3 persons also filed their 5A objection dated such and such. Another 5A objection was filed by the 2 persons jointly on June such and such. All these objections were taken up by the collector for hearing. The third petitioner approached before the collector on August 10th such and such and made submission on behalf of the petitioners. Then this petition was taken up on August 18, 2005. The other objection was heard by the collector on September 16, 2005. The writ petition was admitted on October 5, directing the parties to maintain status quo as regarding the mark that on October 5, 2005, there's a mark directing to parties to maintain status quo. Authorities were making other steps in connection with the proceedings. After considering the report of the government, recorded its satisfaction that the lands mentioned in the schedule of the section 4 notification were needed for the public purpose mentioned in the notification. Thereupon, several declarations, all dated December 1st, 2005, were made and duly published in terms of section 6. Under the circumstances, the petitioners filed a supplementary affidavit dated such and such, stating the grounds for challenging the report of the collector and the declarations. They prayed for an order directing the supplementary affidavit to be treated as a part of the writ petition by order such and such was taken on record, ordering that it should be treated as a part of the writ petition. The petitioner also challenged the report of the collector submitted under section 5A. On several declarations made and published under section 6, questioning the notices issued by the collector under section 12, they filed an application such as which was dismissed by the order. The respondent have raised the question of maintainability of the writ petition at the instance of the petitioners, contending that no one except the persons who have been entitled to claim interest in compensation if the lands were acquired is entitled to question the validity of section 4 notification published or as section 6 declaration made in terms of the provision of the Land Acquisition 1894. Their counsel relied upon the decision of such and such. In response, counsel petitioners have relied upon the decision division makes such and such. It is true. In the decision given by me, I held when the writ petition is not filed as a public interest litigation, a society registered or unregistered, not a juristic person, and not a person agreed by the acquisition proceedings well, unless it says it would be entitled to claim interest in compensation. If the lands were acquired, would not be entitled to take out a writ petition espousing the cause of his member, who might be affected by the acquisition proceedings. But then, in view of the division makes decision, I must say, the present writ petition at the instance of the petitioners, even the society sued for its own name, though in law is not entitled to do that, espousing the cause of the 195 members is maintainable. Cause of action and other objections, though are not the petitioners if they are the members of the society, in view of the division making decision can also espoused by the petitioner. I think. Regarding the question of the petitioner's local stand on further discussion is necessary.
Yes.
The respondents have raised another question of a survival of the challenge thrown by the petitioner to the 4 notification, that is section 5A report of the section 6 declaration. They have stated on oath that out of 197 members, as many as 182 members accepted the compensation once the award was made by the collector. In all the 12 cases during the period from August 18, 2006 to December 17, 2006, and that as many 33 as 33. Section 18 applications included one of the second petitioner was filed. This condition is the members of the society and the second and third petitioners have elected to accept the compensation without obtaining any leave of order from this court, forfeited the right in any to proceed with the case, particularly when the award remained unchallenged. Counsel for the 4th respondent has said that being essentially a court of equity, notice the conduct of the members of the society and the second and third petitioner, I must decline to examine the interest to the challenges. In my view, though I am unable to approve the conduct of the person who accepts the compensation without obtaining any leave or order from this court, especially when the application questioning the section 12 notice was dismissed by this court, I would not decline to examine the merits of challenge thrown by the petitioners to the notification, the reports and the direction, since no compelling reason to hold that the petitioner ever decided to abandon their case before this court. But at first, Kali pause here for a moment, and this is one of the findings for the purpose of adjudication on merit. The acquisition proceeding progress in view of the nature of the interim order made by the court, and in my opinion, the subsequent development, the writ petition should not be disposed of without examining the merits of the case made out therein. It is on record that the persons concerned accepted the compensation recording protest and without prejudice to the rights and contention in rights involved in the present writ petition. I am therefore proposed to decide the case on merits. By a notification dated April 18, 2002, the fifth respondent, that is the Bardhaman Development Authority, was constituted by the state government under the provision of West Bengal Town and Country Planning Development Act 1979 for Bardhaman Planning Area. An area declared as under the Act, it prepared a land use development control plan after following the procedure prescribed by the provisions of that Act. Objections were invited from the persons who might be interested in the land includes in the plan map. He then requested the Urban Development Department to arrange the acquisition of land. Kindly pause here for a moment and kindly mark this. He then requested the Urban Development Department to arrange for acquisition of the lands for implementation of the plan. It wanted lands for construction and development of the satellite township in order to check and arrest the tendencies of unplanned and mushrooming growth in the neighborhood of Bardhaman town and to provide residential area in a planned and environment-friendly ambience with all modern amenities. The land mentioned in the schedule to the impugned section 4 had been included in the map of that plan. In view of its request, the matter was set in motion by the department concerned of the state government. Following the procedure mentioned in the land acquisition manual, the matter was referred to the screening committee concerned. After examining the proposal thoroughly, ascertaining the suitability of the lands mentioned in the schedules to the section 4 notification, the screening committee recommended for their acquisition. The matter was then taken up by the cabinet and approved the proposal for acquisition of the land for the purpose of for public purpose on February 22nd, 2005. Thereupon, the Land and Land Resources Department of the state government issued a letter dated such and such approving the acquisition of the land for construction of a satellite township. Immediately thereafter, the development authority sent the requisition to the collector for taking necessary steps for acquisition. Under the circumstances, the collector issued and published the section 4 notification. In the collector stated, land is likely to be needed to be taken by the government at the public expenses for a public purpose. So it is the case, my lord, stand taken by the government that this project is for public purpose and the money will be paid from the public exchequer. Because my lord knows very well than us, my lord. So far, there are two provisions. One is for the public purpose, one is for the purpose of any other company. If it is any other company, my lord, separate provisions are there. The monetary compensation is something different and entire money will be deposited and something other things. But for the public purpose, there is no such objection can be raised. So it is a satisfaction to the government that yes, it requires for me and that is a motor object. In their objection, the additional objection of the petitioner contended the acquisition proceedings were bad since the procedure for acquiring land for a private person was not being followed. The acquisition for agricultural land was against the morality, humanism, and fundamental rights of a citizen. That since the intended purpose for the acquisition was commercial exploitation of the land for profiting by a joint venture which active participants are private promoters. It was clear case the government's colorable exercise of power amounting to fraud on the statute, and since the government was not spending a penny for the acquisition, it could not be said to be an acquisition for the public purpose. So it is the specific stand we have taken before the earlier court also. Now, my lord, can you turn to what was the stand taken by the Bardhaman Development Authority? Next page, my lord, can you give us the next page?
Last paragraph.
Last paragraph, he recorded. The submission made by the representative of the Development Authority. The observed, the considered, the above points put forward before me, it transpires that the ownership is going to be setting up under the care of BDA. In the notification, the objection has clearly been explained. It reveals that the acquisition is for the purpose of public in general to meet up growing demand of housing for the people for the adjacent rural areas. There is necessity of planned township in adjacent areas of the Bardhaman municipality. The land losers are entitled to get due compensation as per provision of LA Act 1 of 1894. In my opinion, the interest of land loser will not be hampered for this compensation. Regarding the other objection, he observed that the persons who claim they are running their business from the land concerned has been using the land illegally and without hampering the purpose of the acquisition. It is not possible to exclude their lands from the fold of acquisition. On receipt of his report accompanied by the record of proceedings held by him, the state government recorded its satisfaction that the land mentioned in the schedule to the notification were needed for public purpose. In the notification, thereupon the declaration was made published. In section 4, notification questioned on the ground that the acquisition was for a public purpose, but for a private profit-making purpose. Council referred me to the news item reported in a, that the minister of the state government has said in a public meeting that the government will not spend a penny for the acquisition. He has contended that the acquisition cannot be said to be for a public purpose, since on the land of a development work for benefit of a particular section of residents of Bardhaman, it is to be undertaken by the private promoters. The further ground for which the section 4 notification is challenged is that they are issued as acquiring agricultural lands without first obtaining permission from the land reforms authorities to convert the same to the residential use. Now, I can turn to the next page. What is the findings of the coordinate bench on the earlier occasion regarding the colorable exercise of power?
117.
116 was the middle paragraph. With respect to the acquisition of color. Oh.
Thereafter, 117, that is the finding in my view.
In my view.
Place that.
There is no reason to say the acquisition was not for the public purpose. First, the purpose was stated by the notification is no uncertain terms. The recurring body is the development authority constructed in terms of provision of the statute. It was constituted for the planning area in which the exercise is power in terms of the statute. In exercise of such power, it is duty prepare the land use and development plan. The persons who might be interested in the lands included in the plan map were given statutory opportunity of submitting the objection. Plan was duly approved and published. The compensation to be awarded to the acquisitions was to be paid wholly out of public revenue. The development authority was to and is actually did pay it. It was this observation. Come on, pause there for a moment and kindly turn to the opposition filed by the state.
All right, please proceed with this order. Thereafter, I will come.
As your lordship. Yes.
Yes.
There is nothing to suggest that land was sought to be acquired for any private person or complex. Private person or company. There was no reason to apply the procedure applicable to acquisition for a company. I fully agree with Mr. Advocate General that even if the satellite township once established by benefited all a section of residents in the area, it cannot be said that the purpose of acquisition is not a public purpose. He is right to say that unless sufficient materials are produced, the allegation of colorable excess power cannot be sustained. Now, my lord, if your lordship can turn to page 121.
Yes.
The section 6 declaration, page 121, your lordship find. The section 6 declaration have been challenged on the ground that the previously acquired land in the locality has remained unused and unutilized. The government ought to have decided to release the land in question under the double crop agricultural land ought not to have been acquired when the lands were definitely serving the public purpose. The contention of this aspect was not considered by the government while recording the satisfaction. And ultimately, my lord, can you turn to the last page?
It is not correct.
It is not correct.
Yes.
To say that when the two competing public purpose exists, the court possesses the power to balance between them, deciding one should prevail. In my view, doing so, the court will assume the power of the appellate forum.
Last sentence of that paragraph.
Dismissed it. Dismissed.
The line before that. The sentence.
Yes, fails and accordingly dismissed. There shall be no orders to go. Before that, I do not find reason to say government did not consider all aspects before recording its satisfaction. I see no reason to interfere with section 6 declaration. So it is.
That is the ultimate finding.
No, this finding based on two facts.
Yes, yes. Public purpose.
Public money.
Yes.
Now, my lord, kindly turn to the affidavit filed by the state. because everything was
It's annexed here or it's
annexed, page 90.
19.
90.
90.
Because everything boils down to this aspect, whether it is for the public
Affidavit
purpose.
filed by the state in the earlier proceeding.
Yes. Boils down to only one point.
No, not the state, this is Bardhaman Development Authority.
No, this is the Bardhaman Development
90
Authority.
is Bardhaman
What
Development.
was the development? Because there's a recurring, they have already consisting, and
Yes.
I'm drawing lots of attention. So for the page 94, L.
Yes. Yes.
Now, my lord, next page, page 95, third line from the top. The acquisition is at the expense of. Okay.
Yes.
The internal
The acquisition is at the expense of
BDA
yes.
in form of requiring body, and BDA is raising fund with the help of private participation, implementing the aforesaid public purpose. The respondent number 4 is a private party who has agreed to construct and develop the township in accordance with the terms and conditions provided by the BDA. 4 is, my lord, can you consider pause here for a moment? Who is 4? Can you turn to page 57?
So this is the earlier writ petition.
Yes.
Yes.
Bengal Sachi Housing Development. So the stand
They
taken
were engaged to develop.
only for the purpose of development. Because it's the respondent number 4 is a private party who has agreed to construct and develop the township in accordance with the terms and conditions provided by the BDA. The selection of respondent was pursuant to advertisement in the various papers, notifying the expression interest, such and such. In that project, the private partner will have to execute the project on behalf of BDA in terms and time-bound manner, according to the work schedule fixed and mutual consultation of the BDA in
They will act under the supervision of BDA.
They have no independent interest
Under the supervision of BDA.
So they are acting as a contractor or agent of BDA.
Yes.
Now, my lord, if your lordship can turn to page 100.
What is that?
Last but 4 lines from bottom. 1, 2, 3, 4, 5, 6, 7 lines. Or it is for commercial exploitation. My lord, got it?
Yes. I deny that.
The notification of the acquisition is not for public purpose or is for commercial exploitation. My lord, got it? Or is an act of fraud upon the statute in guise of purpose or otherwise, or has been issued malified, or has been made to deprive any common people or members of the petitioner and their properties to means and livelihood. I deny that the compensation has not come out of the public revenue. I state that the entire compensation has been paid by Bardhaman Development Authority and received by the persons concerned by way of checks and issued by the state of West Bengal through a collector. I deny that the land of the building to be constructed thereon, such and such. I deny that the 500 crores is being spent by private promoters or developers for the purpose of acquisition, or the actions for the respondent is not the public interest. Because our allegation was that for the purpose of Sachi, this acquisition was taken out. Now, my lord, can you turn to proceedings were going on. Now, my lord, section 18 came forward. It was filed. Now,
what is the challenge in this?
Now, my lord, subsequently it appears they have admitted it is for the purpose of the company and the entire acquisition money has been paid by the BD Sachi.
What are you challenging in this writ petition?
Yes, writ petition. That is now, my lord, I am challenging the acquisition proceedings because entire because we are not the I am not the party in the initial subject to action. Now, my lord, it appears that is what, my lord, I am drawing to lordship. This is the entire fact which I placed with your lordship is on the basis that it is for the public purpose and out of public exchequer. Now, my lord, can you turn to page 162? This is an application filed before the executing court in section 18 proceedings. My lord, it is not read. My lord, in such a proceedings, the question cropped out whether you are a necessary party.
Sir, I only one thing. In the earlier round of litigation, your challenge to the section 6 declaration that failed.
Yes, on the ground.
On the ground that it was for a public purpose.
And out of public money.
Out of public money, it was held so. So now again in this writ petition, you are challenging that subsequently on the basis of some documents you have come to know that it is being paid by a private party, so it's not for a public purpose.
And
that is the sum and substance of the challenge in this writ petition. Can that issue be gone into in a subsequent writ petition when the issue has been once decided by a coordinate bench?
Coordinate bench, my lord, kindly consider it came up for consideration also. Coordinate bench or the kindly consider the review. If a materials which has not been brought to the notice of the court,
this is not review, Mr. Rai.
The power of review, what is followed from a lordship, that is a constructive res judicata or res judicata.
Review, you have to apply for review.
No, I'm not.
Maybe
whether I have a party
materials you have got, which may be a ground.
Whether I have a party to the earlier proceedings or not, that is also subject matter. Whether I am a party to the earlier proceedings or not, that is also.
You are not party. You said you challenge.
That is why I am challenging.
No, the India.
No.
Someone else challenged.
A committee challenge where there are 197. In my writ application,
who are you? You are the member.
I am one of the landowner.
You are a member of that association.
No, not the member. I am individual landowner who is challenging independent right, claiming independent right of the property, apart from the proceedings which has been initiated in the writ application.
Yes.
Your Lordship, litigating under the same title is section 11. Litigating under the same title, he need not have been part of the association. If he litigates under the same title, he is bound by res judicata.
Yes.
Yes.
Now, my lord, whether fraud can be computed, that will come, my lord, whether fraud can displace the ground of res judicata or not, and what extent a person can be termed to be litigating under the same title. That is something else. My lord,
yes.
Now Sachi came forward and filed an application in the proceedings, in the execution, that I am the necessary party.
You are trying to show page 162.
Yes.
Yes.
In such proceedings, their application was turned down. Challenging that order, they came before this honorable court. What was the stand taken, my lord, can you consider? Paragraph 22.
What was this proceeding for?
This is the section 18, my lord will find that in the compensation was directed to be paid, enhanced compensation, execution proceedings. Then this Sachi came forward and said that I have to pay the entire compensation amount, so I am a necessary party. And allow me to add in these proceedings. That was turned down. Challenging that order, my lord, this was the writ petition filed, whether it is a necessary party or not, subject to question.
Should not be placing this. This has been set aside by a division bench, and subsequently that setting aside has been upheld by the Honorable Supreme Court.
Yes, everything else
are not here.
Probably my senior friend has not gone through my reply and other things, because this is initially what was there, subsequently all came, all are annexed. Be rest assured, I will not say anything which is not there.
He did not place this. This is no longer on record.
I can, subject to question, in the Evidence Act, section 1517 is there, whether I can rely upon the pleadings and other documents which are used by them in other proceedings.
Yes.
Yes. Page 169, paragraph 22.
169.
Yes.
Yes.
On the point of locus standi, Mr. Spall submitted that deciding the issue of maintainability of writ petition on the in spite of ability of alternative remedy by necessary implication of the court decided the issue to locus standi in favor of Sachi. Since unless Sachi is a person interested in compensation as defined under section 3B of the Land Acquisition Act, it would not entitled to maintain either an appeal or a writ petition. Mr. Paul submitted that since no appeal has been filed by the respondents from the order such as such, the issue to locus standi of Sachi is maintained and presented at its finality. A partial locus standi to challenge the order of higher valuation passed by the reference court under section 18. If he is a person interest within the meaning of section 3B of the Land Acquisition Act provides that expression person interested includes all persons claiming an interest in compensation to be made on account of acquisition of land under Land Acquisition Act, and a person shall be deemed to be interested if in the land if he is interested in an easement affecting the land. Under memorandum of agreement entered into between the Bengal Sachi and BDA for development of Satellite Township, Bengal Sachi had an obligation to pay the actual cost of acquisition.
Yes.
Then, my lord, who is, I put this question to myself, then who is paying the cost of acquisition, my lord? The Bengal Sachi.
Yes.
By determining by the land acquisition collector. So this is a compensation amount will be paid by the Bengal Sachi to BDA. And same was with routed.
So according to you, actually the requiring body is Bengal Sachi.
Bengal and for the benefit of Bengal Sachi. That will come, that ultimately they have accepted, yes, it is for ours. This acquisition was done.
Yes.
And also the addition cost in connection with the acquisition, like subsequent payment to the land loser in pursuit of the court's order, such obligation now that the Sachi in view of anonymity of the parties, whereby Sachi has stepped into the shoes of Bengal Sachi. The recital of the said agreement also established the shame of acquisition was done by states BDA's obligation to arrange pay compensation to the discharge by Bengal Sachi.
Yes.
And subsequently, Sachi have already paid to BDA the compensation awarded by the collector.
But Mr. Rai, if this order has been set aside.
No,
This order
on what score? So I am on not on that. I am not on that regarding the. I am on the pleadings. Not order pleadings, and I am on the pleadings which is made in the writ application. Whether I am entitled to rely upon those pleadings, because what I have stated is the case made out in the writ application. I am not the findings, ultimate findings, and what are the ratio decided in this. Whether I am entitled to rely upon those pleadings or not.
Their admission in the pleadings.
Whether I can rely upon or not, even if the suit dismissed. Whether 1517 is barred.
Even if it is withdrawn, suit is withdrawn.
Whether I am entitled to rely upon those pleadings or not. Whether it can be used as an evidence.
Admissions in the pleadings of a withdrawn.
Unequivocal admission in respect of the fact I need not to be proved. Section 15 and 17 on the Evidence Act.
Yes.
প্লিডিং গুলো দেখা অর্ডারটা দেখাচ্ছিস
তুমি যদি মনে হয় আমি কিছু ভুল বলছি, প্লিডিংস এটা ছিল না। The in accordance with the terms and memorandum of agreement, initially Bengal Sachi, subsequently Sachi have already paid to BDA the compensation awarded by collector. Implication of the said scheme of acquisition is also evident by the fact that BDA is now demanding enhanced higher valuation of the compensation awarded by the reference court from Sachi. As a Sachi has an interest in the compensation, hence is the person interested as defined by Section 3B of the Land Acquisition Act. Pause here for a moment. This honorable court held initially that he is the necessary party. When the division means hell no. You are nothing but a party, a requiring body, and subsequently. So requiring body might be interested party, not you.
So actually the effect of the finding of the Honorable Division Bench is that BDA is the requiring body and not Bengal Sachi.
Yes. Requiring body. Because in a execution proceedings, my lord, can you pause there for a moment? What is honored today before your lordship is the actual whether fraud practice of the statute or not.
Mr. Rai, maybe that Bengal Sachi took a point that the acquisition was for Bengal Sachi.
Yes.
But the,
then
but the Honorable Division Bench held.
Now, my lord, what
the requiring body is BDA.
Now, my lord, what the division bench has said, my lord, that I'll come, my lord. Ultimate, my lord.
Yes. Mr. Rai, look to the front. Don't turn right or left. Yes, left you can turn. Left to take instructions, but not on the right.
No. Still, the seniors are there, my lord. We have to learn from our seniors.
Yes.
Huh? If your lordship, last portion, page 185.
Yes.
Division makes a judgment to what corner can I answer? In view of the aforesaid order, the reference court, the reference case initiated by Respondent 6, 17, and 25 in the prisoner set aside. The reference case remanded back to learned additional district judge Bardhaman for being decided afresh giving alternative hearing to the petitioner company. So this was the where the ultimately the writ application was allowed. Division makes a judgment.
Yes.
Yes. এখানে আছে।
This order was challenged.
Yes. Give him ইয়েটা দেখো ওই ইয়েতে গেল না না ইয়ের জাস্টিস ব্যানার্জির কাছে এটা হ্যাঁ 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 হ্যাঁ। কারণ এটা তো রিপ্লাই হয়েছিল দেওয়া হয়েছিল তো
Yes.
Yes. If your lordship can turn to কি give me 1 minute, 1 minute. Judgment কোথায় গেল? এই দেখো ওটাই তো আসল তো ওটা ইয়ে করেনি এটা আমারটা লেখা ছিল তো জাস্টিস ব্যানার্জি আর সুপ্রিম কোর্টের জাজমেন্টটা দুটোই নেই Now I'm in position. I made a compilation of দুটো judgment আছে তোমার কাছে? Those two judgments are made by a compilation. It was not been initially annexed. It was made compilation.
Yes.
But
File that.
no, it was not there. It is subject subsequently came.
Yes.
Now I am facing difficulty when that. Now I am facing. I have instructed my everybody to bring it in a compilation so I can place these two judgments. One before this division and the apex court.
Mr. Banerjee, are you carrying those judgments?
Sent for them. They are in electronic form, but they are not in electronic. Or it will take a bit. It will take a bit. It will take a bit because I also anticipated that he will be citing all three judgments back to back because that has been set aside by two superior courts.
Yes,
Set
yes.
aside and
Upheld by the honorable apex
upheld
court.
with directions. But my lord, I didn't anticipate he wouldn't be bringing it actually. But I might take a little bit wrong-footed.
Hey, দুটো
Do we come back on Monday then? Kindly keep it on Monday as a continuing matter.
নেই এটা
ওগুলো দেখাতেই হবে না নাহলে
আমি বলছি তো দাদা আমি কি বলেছি দাদা
You're not carrying that.
There is a true judgment.
I have my application CAN 1, which I have filed CAN 2 from BDA, and I am told there's also a CAN 1 from Shachi, praying for in limine dismissal of
You are appearing for Bardhaman development.
I have applied for in limine dismissal of the writ petition, primarily on the ground of what fell from your lordship, res judicata. Now it's absolutely clear. Justice Dipankar Datta recently in 2024, speaking for the Supreme Court, has said even if new documents come in, res judicata can't be upset. And litigating under the same title has also been explained. I mean, if there is a association of which there are 40 members, let us say there are 900 other persons who are not members of the association. That association raises this issue, conclusively fails. Subsequently, one of the 900 can't come and say, no, I am immune from section 11 because I was not a party there. That is why in the body of section 11, the term is litigating under the same title. That means
and the issue
you are also a land loser.
Issue.
And if you are also aggrieved in a similar vein as the person there was aggrieved, then the matter goes. New documents don't make a change. On that point, Lord, there is an application for demurrer. That's mine is CAN 2.
It is CAN 1, my lord.
Kindly also,
Do you wish to file any opposition to
if
that?
he wants, he can file an opposition. If he doesn't want,
This is only the writ petition, that is why it is big money.
the writ has been annexed. all that has been annexed here. না না এটা পাতলাই আছে, আমারটাও তো পাতলা আছে, ওটা থেকে ভয় পাচ্ছি।
ও এইটা দরকার নেই।
Sir, do you wish to file any opposition?
Can 1 and Can 2 are both demurrer applications.
Can 2 I have received Can 2. So but the Can 1 is concerned.
You have not received.
Can 1 দিয়ে দাও,
Can 2 just now I received.
Can 2 just now you have received.
And Can 1?
I'm told that Can 2 was served on him just prior to the hearing. He's absolutely right. Can 1 has been served on him now.
No. Sir, do you wish to file any?
My lord, if necessary, my lord, only 1 week. 1 week.
একটা শর্ট নিয়েছে।
দেখো না যদি দরকারের দরকার আছে, নাহলে কি দরকার ফালতু সময় নিয়ে।
Mr. Rai, the learned counsel for the petitioner commences his argument. At this stage, Mr. Banerjee, learned senior advocate appearing for the Bardhaman Development Authority, submits that the state respondent has taken out a demurrer application. Copy of such application, demurrer application being Can, your application is 2, Can 2 of 2024. A copy of such application has been served upon Mr. Rai, the learned advocate, learned counsel appearing for the petitioner in course of hearing.
Can 2 I have just
In
served
course of
prior.
hearing of this application. The learned advocate appearing for the
Respondent number 6, man.
for the sixth respondent submits that the said respondent has also taken out a demurrer application being Can 1 of 2024. A copy of such application has already been served upon the learned advocate for the petitioner. Mr. Rai prays for some time to file oppositions to such applications. Let affidavit in opposition to the aforesaid applications be filed within a week. Within a week from date. Reply thereto, if any, be filed within 3 days thereafter. List this matter on 27th. Under the same heading.
Maybe then without prejudice to that demurrer, maybe then also file our opposition in that same short time. No difficult.
Now
sent to the main writ petition.
Without prejudice. No, that has not been filed. Without prejudice to the demurrer. I'm not giving up the demurrer. Without prejudice to the demurrer, may I file it? No, within the same time. 7-3.
No, if they file the opposition to the writ application, then that regard to be considered.
No, 7-3.
Then I did something because today they filed this application. I have to consider only this.
7-7.
Mr. Rai, there are two things.
Either
if I succeed in the demurrer,
they do not succeed on the demurrer,
then I'll have a right to file an opposition.
Another fresh round of hearing has to be made.
That is what
that can be cut down.
That is what if they file
wants to file the
I want to file our opposition.
If he wants to file the opposition, let them file by 7 days.
Yes, that is what
in other way. Now there is direction for filing opposition on our part in respect of demurrer application by 7 days.
Yes.
What I am praying before your lordship that let them also file the opposition by 7 days, so I can file opposition to both this application and reply
7-3 same. He can come.
He is saying after you file your opposition he will be to the main writ petition, he will be filing a composite opposition to the,
then it will be
that will be your reply, because Mr. Rai, he will be getting a chance of reply in the demurrer.
Yes, that
so then
that
there
can
will
be
be a
taken away.
difficult.
Let it be separate. If you want
So
it within
only
short time,
on the demurrer application you file the opposition, you take all points in the
the
reply.
Once it is there in the reply, there is no difficulty.
As paid for by Mr. Banerjee, you have also not filed the opposition.
No, man.
No.
You have also, you are assisting Mr. Banerjee. Sixth respondent, you have also not filed. As paid for by the learned advocate for the respondents, let state has filed the opposition.
Only state, and we have filed our reply.
State filed.
State filed.
Well, as paid for by the learned advocate appearing for the respondents, accepting the state respondents, let affidavits in opposition be filed by the state respondents within 7 weeks, 7 days from
Then because this
Like,
two
if
is
any
If he wants
file,
more, then let
because
it be
two is there, my
let
lord.
it be 2-1 then, my lord.
I could have actually anticipated
but 2 weeks.
2 weeks.
তাহলে my lord, then
One
my
week.
lord, তুই 1 week লাগবে তো?
আমার 2 সপ্তাহ লাগবে।
My lord,
Mr. Banerjee, you do demurrer application, he will be giving by 1 week. Let the
This can be
affidavit-
prepared. My lord. Nowadays there is no difficulty that way, but 7 days, if your lordship makes it
10 days or 15
slightly
days?
slightly more.
Because this is a thick.
No,
I have
the
to check up
the
the
materials are all with us.
when can you file?
2 weeks.
2 weeks.
Maximum.
So 28, let affidavit in opposition be filed within 28th of February 2025. Reply thereto if any.
10 days or something.
Yes.
Only
Yes,
because
I have
authority goes.
So they will be filing opposition. Reply.
1 week. That because already all the papers will be there. So I'll not take it.
Mr. Rai, they are saying they can do affidavit in opposition within 1 week. You are extending by 2 weeks.
No.
You said by your demurrer application.
Is this demurrer application that if I
Demurrer application you want 2 weeks.
Cross direction.
I'll do by 7 days.
তাহলে ওই 1 week যেটা ছিল
1 week, 1 week.
হ্যাঁ 1 week টাই করে দিন 1 week 3 days
27th.
27th 1 week 3 days 27th
1 week 3 days. না না
দুটোই।
ওদের ওই ঠিক আছে
একটা হচ্ছে অ্যাপ্লিকেশনের অপোজিশন হ্যাঁ আর একটা হচ্ছে মেন পিটিশনের অপোজিশন দুটোই অন্যজন দেবে কিন্তু টাইম লিমিট সেম টাইম লিমিট সেম কারণ ওই পিটিশনার হচ্ছে অপোজিশন দেবে টু দ্য ডেমারার আর ওরা রিপ্লাই দেবে টু দ্য ডেমারার ওই 7 days আর 3 days আর ওটা উল্টে যাবে রেসপন্ডেন্ট এফিডেভিট ইন অপোজিশন ফাইল করবে উইদিন 7 days আর রিপ্লাই ফাইল করবে বাই দ্য পিটিশনার উইদিন 3 days.
Sir, I had a prayer.
Along with the application,
I had a prayer, my lord. I am being fervently requested to make a prayer before your lordship, my lord, for slightly more time because of the fact that your authority is involved. They will wait, come, etc. Otherwise, my lord, I will be embarrassing your lordship.
within 2 weeks, 1 week,
3 weeks.
2-1-3.
2-1-3.
And my lord,
Directly appear, my lord.
my prayer for
date করে দেবে না
হ্যাঁ my lord.
returnable on a particular day. Yes.
Except Monday.
And my lord, only one.
Except Monday. My lord knows nowadays my lord Monday is for mentioning day for us.
সারাদিন mention. Yes.
Continue here.
hearing
My lord,
Continue.
my only one prayer, my lord.
Continue here.
substantially hard.
Substance my lord only make it.
Whatever. No, can't stand in the way, whatever. My lord, only one prayer, my lord. My prayer for my lord affidavits is without prejudice to the demurrer. Would you lordship? Otherwise, that might also be argued at sometimes arguments we make like
It is however made clear that the
direction for exchange of affidavits in the
for
writ petition
exchange of affidavits
are without prejudice
in
to the
the
demurrer.
main writ petition is without prejudice to the rights of the respondents to raise the point of demurrer at the time of hearing of the writ petition.
Continue. Continue, but I have already completed. These are the points which I'll argue. After that, I'll complete my argument. Continue. Yes, continue.
Continue না এক করে দিন ফিক্সড ম্যাটারে করে দিন
হ্যাঁ fixed matter.
ফিক্সড ম্যাটারে
Fixed matter.
করে yes next
Mrs. Maiti is appearing through online. We are for the private respondent.
you are for the petitioner who is municipality who is for the municipality
That takes it up next week.
next week not today
Only no.
not today
Lordship, I am appearing for the petitioner, Your Lordship.
32
In 32,
yes
Your Lordship.
who is for
Lordship,
the respondent
there was a direction for affidavits, Your Lordship. It was passed in 2021. On the last occasion, also time was sought for extension.
nobody is appearing
Your
there
Lordship,
is a resolution also
yes, Your Lordship. Kindly fix the date, Your Lordship. Kindly do not.
not today Monday it will appear yes next
I'm for the respondent.
respondent not today
34.
not today
5.
35, my lord, I am appearing
Yes,
for
35.
private respondent.
You are for the petitioner.
Petitioner, my lord.
Who is for the state? Mr. Datta for the state.
Mr. Rejaul Alam.
Required to file the.
Then
My state is required to file the report, my lord.
not today. There is a resolution today. You have taken a resolution.
Resolution अच्छा आज की.
My lord, kindly fix the time, my lord, Monday, so that, my lord. Not kindly, my lord.
Matter is appearing in the list.
Every
Chronologically,
day it is appearing, but my lord.
fixing a time is
Consider, my lord.
After also one if it was for fixed, my lord. Any time, my lord, may be fixed, my lord.
time
Precise.
serially it will be taken up. When your serial will come, that is the time which is being fixed. List is fixing the time. No difficulty. Yes, next.
Six months I appear for the state.
For the university, my lord. Perhaps in this matter, the petitioner lost his interest because this is the fourth occasion he never appeared.
Mr. Bhattacharyya, the difficulties
Yes,
for
yes,
today
yes,
because there is a
yes.
resolution.
Yes.
Yes, that is
Just
Other-
inform.
I
I'm not
think for
asking for
nothing
any
survived.
adverse order, but just informing. This is the fourth.
I appreciate that, but if it had been any other day, it could have been because today.
Because of the fact there is an order of interim order whereby this principal used to visit the college with the police help, and he always visit the college.
That interim order has lost its force.
No, that is there, and that is the reason the petitioner never tried to pursue the matter.
All right, এটা দিন অর্ডারটা একটা রেকর্ড করে দিই
Interim order টা করবে।
And
দেখি
the-
দেখি দেখি এখানেই আছে protection.
But if your lordship kindly come to the order dated 24th August 2020.
Order dated
24th August 2022, page 3, paragraph 1.
Page
3, first paragraph.
Yes.
In that view of the matter, I direct the officer in charge, Bardhaman Police Station, Purva Bardhaman, to ensure and provide protection to the petitioner so that he can join his duty.
You are for the university.
I'm for the university.
Ashun. None appears for the petitioner at the time of call.
And
Mr.
also
Mis-
previously at least, I don't know whether that has gone on
Yes,
record.
that has also been recorded 11th of November 2024. The university and the state, Mr. Datta, you are for the state.
I'm for the state.
The state are represented through their learned senior councils. First up, Mr. Bhattacharyya, learned senior council representing the university submits that taking advantage of the interim order dated 24th of August 2022, the petitioner is avoiding to appear in this matter. First up, however, since the Bar Association has taken a resolution, the hearing of the matter stands adjourned for the day. Who is the learned advocate for the petitioner?
Mr. Alan Felix initially appeared, but I have been
It
informed
will
that
be open. Can you serve the learned advocate?
the difficulty is Mr. Felix issued no objection.
And possibly nobody is representing.
All right, let it appear. Hello.
The default clause, kindly add one default clause in the event of absence of the petitioner next time, your lordship will pass appropriate.
It is, however, made clear that if on the next occasion the petitioner is not represented, necessary orders will be passed in the absence of the petitioner. Necessary orders may be passed in the absence of the
He is
petitioner.
getting police escort by order
The
of.
college, when he is running in the college, he come with the police,
And this-
and it's a different attitude altogether.
So, Bhattacharyya, the situation must be such that the honorable
The
honorable
dispute
court
between the
found that that order has to be passed. So,
there is a dispute between the Kormochari union and the principal.
that is, it is
That is
one
the reason
thing
the order passed.
that order is to be vacated or the writ petition is to be disposed of. But today,
No, I am not pursuing that.
yes, next.
Last you get.
37, my lord, I'm for the petitioner.
Mr. Ghosh for the respondent. Any
Yes.
private party?
On
Yes.
private battery, my lord, I have served.
There.
No, my lord, then initially they appeared. but they are not file any
Today
opposition.
there is a resolution.
No, my lord, thereafter, on the last occasion, as per direction, I have served notice.
No, my lord is saying today's resolution that if
It's a resolution.
Yes.
nobody is present, then there is a whether he's but a proper necessary his assistance is required or no.
That's the whole thing. Because there's a resolution, I'm making it only not today.
My lord, I have intimated over phone, and he said,
Okay.
I am not interested in this matter.
Make that
and
submission
refused
on
to
the
act-
next date.
Not
Because since
interested.
there is a resolution, I'm adjourning it. It's not that since you have not intimated.
It is true, but my lord senior is also very busy at this matter.
Lawyers have to be busy. Their professional matters. Yes.
Yes.
But Mr. Ghosh, even then he appears, regularly attends the matters.
Yes.
Yes.
So, my lord, kindly fix this matter on Monday.
Yes, it will appear in the list.
I'm grateful. My lord.
I'm making it only not today.
My lord.
Yes, next.
My lord.
39 to 46.
38.
39 to
38.
39 to
38, I appear for the petitioner.
39 to 46,
39
yes.
to 46.
You are for the
My lord, 38.
My lord, 38, my lord.
I appear for the petitioner, my
My lord,
lord.
in this matter, Mr.
38 তে ডাকলেন না। Oh, 38,
My lord,
yes.
in this matter, my lord, Mr. Pradip Tordar, my lord, leading me, my lord. Today he is unwell, my lord. Kindly take it on Monday, my lord. Monday, my lord, kindly.
My lord, there is some urgency in the matter. My lord, the petitioners herein have been, my lord, they are the employees of
Din.
Damodar Valley Corporation, my lord. They are working as assistant grade 3 clerk cum typist.
Yes.
My lord, on the basis of our recruitment process, which was, my lord, initiated in the year 1990, merit panel was published and appointment letters were issued to persons whose names featured lower down in the merit panel in supersession of the rights of the petitioners. Thereafter, my lord, a writ petition was filed. During the pendency of the writ petition, my lord, DVC had issued appointment letters to these petitioners in the year 1993 to 1994.
You want the uniform career progression.
Yes, because my lord,
The respective dates when your juniors have been granted such benefit.
my lord. And we are lacking, my lord, for a period of 2.5 years. My lord, deprivation is twofold. One is on the basis of salary, and secondly, my lord,
Take
deprivation.
it Monday, my lord, Mr. Tordar.
My lord, continue to persist by reason of, my lord, erroneous pay fixation. My lord, without.
She's opposing. What can be done?
Yes, my lord. Only if the matter could be fixed, because my lord, petitioners are
Take it
retiring.
Monday, my lord, kindly.
Some of them have already retired. My lord, I am only, my lord, beseeching a lordship if this could be
My lord,
fixed.
nothing will be happen, my lord.
My lord, on previous many occasions, time has been taken, or either. না, আপনারা আসেনি।
You cannot make your submission.
Kindly drop the risk.
Why?
No, my lord, kindly.
If required,
My lord, kindly,
I
my
will
lord,
fix
kindly,
this on
kindly,
the
my lord.
next day.
My lord, kindly, kindly.
I will hear Mr. Torobdar. You can make your submissions today.
My lord, kindly take it on Monday, my lord. Actually.
Then if your lordship kindly allows me to place the matter today, my lord, on the next occasion, my lord, they can come back. And I am also led by Mr. Shomo Mujumdar. ये থাকবে, sir.
All right, not
My lord,
today.
then may I file the exception to the report?
Exceptions to the report.
Report.
Yeah,
You have filed your report.
I have filed, my lord. I have already filed.
The record korun. Exceptions to the report filed by the learned advocate for the petitioner is taken on record. An accommodation has been prayed for by the by Mr. Pal, learned advocate, appearing for the DVC.
Yes,
For the DVC. First up, on the prayer of the learned advocate for the respondent, the hearing of the matter stands adjourned for the day.
My lord, kindly keeps it under, my lord, continuing matter or fixed matter.
It will appear.
My lord, kind.
Barely at the top, it
Sir,
will call.
আপনারাই আসেন না।
Yes, next.
আসেন না।
39 to 46.
39 to 46, I am for the petitioner's file.
Yes.
And there are other, my lord, respondents.
Not today, next.
Your lordship, instead of, my lord, Monday, it may be taken about Tuesday.
Let it appear on Monday if you have any difficulty. Yes, next.
47, 48.
Your lordship, I am for the petitioner 47, 48.
What do you want?
Not today, your lord.
Not today.
49.
Not today, next.
50.
My lord, I am for the petitioner, my lord. That this is, in this matter, there is an application for substitution, my lord.
Not today. Next.
It is a matter of 2000, my lord. Kindly
See, today there is a resolution. Yes, next. 21. 51. Yes, not today.
52,
My lord, I am praying not to do.
Not today.
54.
Not today.
4, 5, 56, 57, 58, 59,
My lord, I am for the petitioner, my lord, praying for not today.
Not today.
61, 62, 50, 5, 66, 7, 68,
My lord, I appeal for the petition in 68, my lord. 68. Yeah.
76.
Yes, my lords.
Yes.
My lords, this is that matter, my lords.
The other side is not here.
Other side is not here.
Not today. Next.
My lords, may I kindly seek one indulgence, my lords? I had paid it all, even on last occasion, my lords. My bank guarantee is stuck, my lords. It is a fund-based bank guarantee, my lords. If my lords can fixes it up,
Appearing in the list will
my
be
lords.
taken up. Yes, next.
77, 78, 79, 80, 81, 83, 4, 5.
Your Lordship, for 85 to 100, Mr. Siddhartha Banerjee is appearing. I pray for not today, Your Lordship.
Not today. Yes.
101, 102, 103, 104, 105, 106, 7, 108, 109, 110, 111, 112, 13,
13, my lord, I am appearing for the petition.
100.
113.
113. Yes.
I am appearing for the petitioner. Other side is not.
Not today.
114, 115, 116, 117,
Your Lordship, I'm appearing for the petitioners in 117 and praying for not today.
Not today.
Grateful, Your Lordship.
118, 119, 120, 121, 122, 123, 124.
That 124, I am appearing on behalf of the petitioner, my lord. Matter relates to the disciplinary proceedings of the petitioner, where the final order has been passed, and the in the final order, the observation is made that due to the bank is exposed to a potential financial risk for which the pensionary benefit of the petitioner has been
Withheld.
stopped, my lord, and that's challenging that final order. We have come before this honorable court, my lord. Review was filed. It was the final order stayed, not stayed. The final order is upheld by the review, and challenging that review order also, we have come before your lordship, my lord. May I place this case, my lord? May I place this case? Because we have
The other side is not here. Today you have taken a resolution. Not today.
my lord, a day may be fixed, my lord, any day.
Monday.
125,
25, my lord, I am
Yes.
appearing for the petition, my lord. I am paying for 1 day's accommodation.
Why?
My lord, unfortunately, my lord, the brief has not come, my lord. I have missed the brief, my lord.
Brief is here. You can take my brief.
My lord, kindly 1 day, my lord.
You are ready with the matter. Brief is here.
My lord, I am ready, my lord, but I am led by Mr. Hon Banerjee in the matter, my lord. The matter needs to be addressed.
So Hon Banerjee is available through virtual mode. He appeared in one matter. Through virtual mode.
Kindly, my lord,
If you
accommodate.
start, Mr. Banerjee will join you.
My lord, kindly accommodate for a day, my lord. It's a
Not
enough
today.
procedure, my lord.
Next.
126, 127, 128 to 132,
My lord, will all passport matters.
133,
Which item?
180.
You have missed your bus. Let
130.
be called. Yes.
130.
Next.
33, I am paying not today, man.
Not today.
134, 135, 136, 137, 138, 139, 140.
My lord, 140, I am appearing on behalf of the petitioner, my lord. This matter I am being laid by Mr. HON'BLE Lahiri. Your lordship may remember, my lord, that
Respondents are not here.
yes,
Not today, next.
a date,
141,
date
143, 144, 145, 146, 147, 148.
Your 140, 148, and I mentioned before your lordships for upgradation. My lord, he is not getting pension. My lordship,
148.
148.
Dekhi file ta din.
My lord, the
Who is the answering respondent?
my lord, Mr. Bhaskar Boisho and my lord, the Niloy Das. Niloy.
Mr. Bhaskar Hoysha has not come.
I don't know, my lord, I have not seen him.
He has not come. See if he has come.
Say.
Dekhi file ta din.
My lord, the issue, my lord,
What is the ground on which your pension has been stopped?
the petitioner enjoy 3 years additional increment as headmaster after upgradation from secondary school to higher secondary school. Subsequently, by the government order, benefit as accrued in the government order has been withdrawn. This honorable court, that withdrawal order has been set aside, and my lord, directed that the 3 years additional increment headmaster of upgraded school is entitled because the additional responsibility for higher secondary section. Now the division bench has settled. I have annexed the division bench judgment. Single bench has settled. Commissioner of School Education also said that yes, henceforth, my lord, that I have everything has been settled. Now the issue has been settled.
Are you challenging any order?
No, my lord, since that order has been set aside by this honorable court, I have also challenged that order. But they have, my lord, reduced my basic pay, last basic pay, reducing, my lord, deducting, my lord, refixing my basic pay fixation right from the date of upgrade.
Pension payment order has not been
yet
issued.
been issued.
On that ground.
On that ground.
Page 59.
Page 48, your lordship will find, page 48.
Has it come to court? Page 48.
48.
Mr. Bushra has come, but I have seen him code number 9.
Oh, yes, come. Yes.
And page 50 or page 48 and 49. 49, this is the objection.
Yes.
Pay from 1st July 2010 to end of service seems to be not in order. The
Needs to be recast.
Same need to be recast, overdrawn amount need to be refunded to treasury challan. This is their objection. My lord, your lordship will find page 50. This is very important, on the basis of which I was drawing pay fixation up to the date of retirement. DI himself, my lord, granted as per government order. This government order, GO number 30, this was withdrawn in 2017. This has been set aside by this honorable.
Geo 30 dated 10th of February has been set aside.
No, that has been that by Geo 30 I am entitled.
By? Yes.
That is the DI approval in 2011.
Yes.
That is the page 50.
Yes. That is in terms of Geo 30.
30, I was drawing myself actual melody that was entitled to melody 200 additional 3% increment. You will also second paragraph.
Yes.
Pay further may be refixed as headmaster, basic pay of 26,680 and grade pay 200 and basic pay 26,880 after adding 3%
Additional increment.
This is the melody DI has approved. Now the page 30 I also melody this is the Geo I have annexed.
ইনফর্ম করবি তো
লিস্টে তো রান করছিস
দশটা নতুন বলবি আমরা কি করে
Yes.
কি করবেন
Yes, Mr. Boyso.
But lordship here, lordship was sitting the division bench judge. But how no lordship was sitting here?
লিস্টে তো দিয়েছি
This was published.
List was published to single.
This was published yesterday.
Yesterday.
Yes.
But lordship,
Don't take this point today.
but lordship, how the lordship single bench judges are,
Yesterday it was published in the website.
and lordship mentioned that today he was sitting at 10:30.
Yes.
No?
See in the list.
আজকে দিয়েছে। So lordship, how you know lordship chief justice sir?
Now everything is in the website, Mr. Boyso. You are in the old days.
The old age lordship. We are the senior so lordship, senior citizen so lordship. I have
The
the old
list
age.
also it has been
And
published
lordship is
from
the-
10:30.
Yeah, case to
ওই
Yes.
3% increment যেটা ওখানে
consider পাঠাতে বলছি। যদি
আজকে-
consider হয় তাহলে আমি রাজি আছি এখন করে নেব। আর যদি থাকে তাহলে আমি আর্গুমেন্ট করব। Presentation has been considered by the district inspector school.
Insanity benefit.
No, your representation is pending.
Yes.
No, that is their objection. On the basis of the objection, my pension has been
You have raised an objection on the ground that his pension has been not released. So he was enjoying a 3% additional increment in terms of a government order number 30 dated 10th of February 2010.
and as per approval of the DI.
That was subsequently sought to be withdrawn, challenged before this honorable court. Honorable court has set aside the government order withdrawing this,
Yes. But lordship,
affirmed up to the division bench. So if that is so, you have to sanction the pension.
But here,
You
lordship,
cannot direct recasting in terms of this page
No,
48.
As per the my lordship, remember where there was single bench justice Bhattacharya, lordship Sagoto Bhattacharya released the matter. No, lord, matter was hard for justice, and their
No,
lordship. হয়েছিল মামলা কি বলছি?
Hard to release the provisional pension, that was also stopped.
That lordship I am giving lordship.
Direction for filing
Yes,
affidavit, now the affidavit has been extended.
Lordship exchange.
No, affidavit has-
Then lordship give me some time, lordship. I will come before his lordship.
Monday?
Not Monday, lordship. Give me 1 week time. No, lordship. Just lordship.
Why 1 week time? For what?
For what, lordship?
Opposition reply complete to next.
না দেখলে হবে নাকি? Today is Friday. Give me 1 week time, lordship.
Why 1 week?
No, lord, no Friday, Thursday. Friday is the contempt day.
The voice of pension.
No, Wednesday or Thursday any day, lordship.
Wednesday.
Wednesday or Thursday.
Asun. Mr. Janal Honored Advocate appearing for the petitioner
report
submits that the petitioner was receiving 3% additional increment in terms of, Mr. Jana, kindly hear this. The petitioner was granted 3% additional increment by a memo dated 21st of January 2011. First up, however, subsequently the
No, 21st of January 2011, this is the approval of the DI, government order 30.
Yes.
Dated 10th
By
February.
this you were granted 3% additional. That is
Yes,
what I have
that
recorded. কি বললাম? However, subsequently, what is this page 49?
Page 49, this is the objection of my pension.
However, subsequently an objection has been raised stating that the pay of the petitioner from 1st of July 2010 till the end of his service is to be recast and the overdrawn amount needs to be refunded through treasury challan. First up, Mr. Jana submits that it has been settled by this honorable court up to the honorable division. It has been settled by the honorable division bench that the petitioners, that the similarly situated persons will be entitled to such additional increment. Mr. Bhoisho Lanet, additional government leader. Mr. Bhoisho, you are for the state. The Lanet additional government leader seeks an accommodation in to go through the decision referred to by Mr. Jana. Mr. Jana, please supply the copy. Please give him the copy of the judgment.
Yes, yes.
As paid for by Mr. Bhoisho, please this matter on Wednesday করে দিন under the heading continuing matter.
আরে এইটা যে দিয়েছি না এটা দিয়ে দেবো আর একটা কপি
না না থাক not secret. Lordship, I think the regular bench, Lordship.
Yes, from Monday.
The Lordship, the regular bench. But Lordship, I don't know, Lordship, nobody the bar of the bar association or not don't know. No, the regular bench, but no, I don't know. Which date Lordship is sitting on the chief justice. If
All the list.
the regular bench is continue, that will be better.
Call the list.
এটা কি আমারই বলবো তো রেগুলার বেঞ্চ বসা
বসবি তো রেগুলার বেঞ্চ সোমবার থেকে
151 Lordship, I am for the petitioner.
Who is for the respondent?
The Union of India is the only respondent.
Not today. Next.
152, 153.
153 Lordship, I am for the petitioner.
I am from the respondent. Senior advocate Asian Dotto is severely ill, and I pray
Not today. Next.
I pray for
154. I
But
want
154 for the petitioner.
154.
154 and 155.
Yes.
For the jury appearing for the Union of India, 154 and 155. Yes.
Any private party, Mr. Chatterjee?
No, 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 no.
No private
Kindly
party.
take my lord 155 first.
155. দিয়ে দিন।
I got an interim order on 27th July 2024 from this honorable court. To that effect, the post, as per the number of the petitioner, be kept vacated without it cannot be filled up without the leave of the any.
No, what is the issue? What is the
Issue
challenge?
regarding appointment of the appointment in the post of constable general duty in the Central Armed Forces Tribunal. Issue is that I participated in the written examination. Thereafter, physical efficiency test. At the time of interview, after participating in the interview, my names are not empaneled in the list. I challenge the selection process on the ground that there are some certain candidates who used fake domicile certificate at the time of verification in the selection process, and they are given appointment. Subsequently, one Vishnu Chaudhary matter was moved before this honorable
They
court.
have been given appointment.
Now, what has happened? One Vishnu Chaudhary matter, another writ petition, some of the candidates moves regarding fake domicile certificate in respect of same selection process. In the said writ petition, CBI investigation was directed and CBI registered a case. Now the investigation is going on regarding the fake domicile certificate candidate against the fake domicile certificate. Kindly see, my lord, the order dated 29th July.
If you want now.
If there are the number of candidate who use the fake domicile certificate.
But that is under investigation.
No, no, no.
Till now not
Kindly see
decided.
the internal report. Kindly see the internal report of the respondent authorities.
Investigation is continuing.
Continuing.
No final decision has been taken with regard to that.
Admittedly,
That is so.
but they kindly consider one document, internal document between the respondents, authority of the respondent. They have admitted that 3683 numbers of candidates who use the fake domicile certificate. If they are terminated, then our chance will be
But termination will happen after the investigation is completed, that report
Absolutely,
is
my lord. That is
filed,
not,
then they have to
that
take
is
a
the
decision.
disputed position. But
So if that is so, what relief can be granted to you at this point of time?
how CBI investigation is going on from, kindly see the order of Vishnu Chaudhuri in the year 20, kindly see page.
I appreciate that, but unless and until the investigation is concluded, a final report is drawn on the basis of such investigation, it is placed and a decision is taken, then the authorities have to take a decision on the basis of that.
Kindly
Because
consider-
nobody knows
Yes, yes,
that what will be the fate
of the investigation.
Yes, the
Kindly-
affected parties, they also have a right to challenge that decision.
Absolutely.
Then-
Kindly see page 237.
So no final relief can be granted to you,
No, that I know.
or I can give you liberty to approach after the investigation is concluded. Now what relief you can get?
I tell you, Lordship, one other thing, well, I tell you, Lordship, there's an interim order and direction for filing affidavits. Initially, my lord, I engaged on behalf of all the respondents. Now, my lord, after that, my lord, there are two departments are involved, CRPF and SSC.
Court can engage you, Mr. Bhattacharjee, for all.
No,
the
no.
respondents.
Direct
regularization of your appointment.
I have regularized. Man, there is a problem. I tell you, Lordship. I appeared engaged on behalf of all when the matter was moved. Thereafter, there are two departments are involved. One is CRPF, other is SSC. Then
other is
SSC, Staff Selection Commission.
Yes.
So both two departments gave me two opposition. I said this
Contradictory stand.
different stand.
That will help the petition as Mr. Bhattacharjee.
That I suggested them this is not possible. I cannot file, my junior cannot file such opposition. Either you split up appearance of the respondents or otherwise will release me. I do not want to, if you do not hear me. After long deliberation, they have accepted my suggestion. Now I am only appearing on behalf of the School Staff Selection Commission. For the CRPF, other learned advocates.
Who is appearing?
CRPF.
And July, my lord, there
So
is a
far the-
direction for
so far-
affidavit. No affidavit has been.
And
That
so
is the
far, the
situation.
opposition of the Staff Selection Commission is concerned. Now it has been finalized. Your lord.
What is your stand? No, you have not yet filed your opposition.
July, in the month of
But,
July.
since you have drafted, what is your stand?
Stand, my lord. Firstly, my lord, these petitioners subsequently appeared in this examination. They unsuccessful. Thereafter, they have come. And so far, the other part is concerned.
On the point of debarrer.
No, according to them,
They have prayed for cancellation of entire my lord, selection. But to that one, I shall make
if Mr. Bhattacharjee, this cannot be segregated, then entire process should go.
that if court holds, my lord, this will go. But this will not go, my lord. But subject to my lord, my your lordship kindly give me 2 weeks time, my lord, further 2 weeks to file the opposition. So for the
But Mr. Chatterjee, you may be having a difficult case at the present point of time, since the investigation is continuing. What relief
But the
you can get?
department admitted the, kindly see, kindly consider
Maybe, but
237.
that is an internal report. That is not the final report which has been drawn by the
absolutely
investigating
not.
agency.
Absolutely not.
Then investigating agency has to draw a final report, has to place before the authorities. The authorities will take a decision. Affected parties may have a right to challenge that.
Let them file the affidavit first.
154 and 55, my lord,
You
this
can advise your clients accordingly.
154 and 55, my lord, the same.
Mr. Bhattacharjee Lanet, counsel representing the
Staff Selection Commission.
Staff Selection Commission being the respondent numbers 3 and 4.
3 and 4.
3 and 4 submits that
2, 3, 4. 2, 3, 4.
2, 3 and 4 submits prays for extension of time
Yes.
to file the affidavit in opposition. So as prayed for by Mr. Bhattacharjee.
Your lordship also record, my lord, that other set of lawyers are different, my lord, because I have.
As prayed for by Mr. Bhattacharjee, time to file affidavit in opposition is extended by 2 weeks from date. Reply thereto, if any, be filed within a week thereafter. Mr. Bhattacharjee further submits that initially he had instructions to represent all the respondents but subsequently, he has been instructed to appear only for the respondent numbers with 2, 3, and 4. Bodha bollam. 2, 3, and 4. He further submits that a separate lawyer has been engaged for the other respondents. Full stop. It will be open to the other respondents to file the affidavit. They have also not filed their.
No.
It will be open to the other respondents to file the affidavit in opposition if they so choose, within the time limit as mentioned herein before. ঠিক আছে, এটা কবে বললাম? 2 weeks, তারপর reply for 3 weeks.
Interim order be continued.
It is continuing.
Yes. Without leave of the court, the post should not be filled
So
up.
that is continuing.
Yes.
It's not for a fixed time.
Yes.
After 3 weeks, they appear. Yes, next.
Obliged, my lord. 154, 155 both.
154, 155 একসঙ্গেই অর্ডার করে দিন।
Obliged, my lord. Get.
Mr. Bhattacharya, single order will cause prejudice to you.
Single order will prejudice.
Will prejudice.
Details.
Separate orders করে দিন। Yes, next.
156, 157.
157, I am for the petitioner.
And one for the state respondents.
State.
Yes, ma'am.
Any private party?
No, this is the, my lord, the postgraduate scale of pay.
My lord,
Part
there
one
is
examination was held.
there is direction for every like, may I pay my 2 weeks another.
This has been settled, Adiluzzaman, my lords also in my
Order
case.
is there, my lord, file opposition. My lord. Only 2 weeks, my lord.
Part
Is there
one
any
examine-
factual dispute for which you want to file an affidavit in opposition?
Yes, my lord.
Factual dispute.
Yes, my lord.
Larger bench also settled the issue.
Factual dispute, he says.
Factual cover.
Not legal. Legal, I appreciate your submission.
Factual issue.
He says that there are some
And
factual
only 2 weeks, my lord, kindly, my lord. Last chance, my lord.
The learned, Mr. Jana, learned advocate, appears for the petitioner. First up, the learned advocate appearing for the state submits that there are certain factual disputes in this matter for which an affidavit in opposition is required to be filed. First up, as spread for by the learned advocate for the state respondent, time to file affidavit in opposition is extended by 2 weeks from date. Reply thereto, if any, be filed within a week thereafter. List this matter after 3 weeks. Next.
3 weeks.
158, 159.
158. 158, my lord, this is, my lord, I am for the petitioner.
158, you are for the petitioner. Who is for the state?
In view of the judgment of the larger bench in Abdul Ghani's case, I am entitled for pension
Nobody is
from the
appearing.
date following the date of retirement, not from the date of
Nobody is appearing.
retirement.
Not today, next.
Appear করছে। Yes, my lord, I have given a notice.
Why have you taken a resolution, Mr. Jana?
Niloy Banerjee, Jahangir Badshah.
You have taken a resolution today.
Once, but
You don't want to obey that resolution.
no.
61 to 67, Lord, I appear for petition in some of the matters. Lord, in 4 matters I appear. Lord, 61, then Lord 66.
You are for the petitioner.
For the petition.
You are standing.
Lord, this court, Lord.
I thought you were for the
Lord,
rest.
this court, I do not think this is required. This court, this is not required.
Yes.
Lord, this is assailing, Lord, the new Lord Sand Act, the mining Lord rules. Now, Lord, why this has been challenged? Lord, learned Advocate General had made certain submissions, Lord, at some point of
was
time.
heard.
It was heard.
Then I am releasing it.
Lord, thereafter the matter,
The honorable judge who has heard, let it be placed before that. I am
Lord,
recording that
it
it
will
was.
not be heard again. Lord, kindly fixes a date, because in any event we have to make a de novo hearing. In any event, because
Making
the
it not-
last hearing took place in 2023.
Making it not today.
Yes, Lord, only one prayer, Lord, if a date may be, because Lord, the notice has to be given to the Advocate General.
Date.
So that if Lord possible.
Fixing a date is the problem.
Else,
I can
Lord,
fix it. Monday is the date, next date fixed. Today we are on Friday. Not today. Yes, next.
168,
My lord.
169.
168, my lord, I beg to appear.
168.
My lord, I beg to appear on behalf of the
Who
petitioner.
is opposing you?
Sujata Mukherjee, my lord.
Not today.
My lord, in this case, my lord, day after
Not today. No one is there.
Petitioner had died to
Petitioner has
expired 2 days before, my lord.
expired.
My lord, I have to file substitution
All right.
application, my lord.
The learned advocate appearing for the petitioner submits that the petitioner, sole petitioner, only one petitioner,
One petitioner, my lord.
that the sole
Sir,
petitioner,
this matter, my lord, the date of birth
the
of the
sole petitioner has in the meantime passed away.
2
Prays
days before,
for
my lord.
an accommodation to take steps in this regard.
My lord.
First up, petitioner will be at liberty to take appropriate steps in that regard.
My lord.
First up, liberty to mention after the
My
necessary
lord,
steps.
in this matter, my lord, the
Article.
retirement benefit had not been released by the KOPT, my lord, since 2018, my
Must you
lord.
substitute?
My
Yes, next. Liberty to mention. করে দেবেন।
only
Yes,
give 2 weeks time will be enough, my lord. 2 weeks time.
You do that because if it is within time,
My lord.
substitution application has to be moved before the learned registrar, logima and office management. That is the procedure under the appellate side rule. So that is to be first allowed, thereafter it will come. Yes, next.
169, 170, 171, 172, 173.
My lord, I appear for the petitioner, my lord.
173.
Yes. My lord, this is a very,
KMDA, my lord.
KMDA, yes.
this is, my lord, a case, my lord.
Acquisition.
No acquisition.
So state is the
1980, I tell you, lordship, in
state has to be heard.
It has to be hard. But
What is appearing for the state?
Mr. Chondi Charande. My lord, or my lord, kindly give.
You have taken a resolution.
I have a prayer.
You have taken a resolution today.
I know. My lord, what my lord, I want to say, I will just take 2 minutes and I will make a prayer before your lordship to fix the matter in some day. Because
Monday?
Monday. Lordship,
Monday.
fix it on Monday, my lord.
Yes, not today.
My lord,
Yes, next.
kindly, my lord, fix a time, my lord.
Monday. Not today is Monday. Is
My lord, if some precedent, because why I tell you, your lordship, my lord, I have a
no adverse order.
No, no.
This will be an adverse order against the other side. Upgrading.
no, grading is not adverse order. My lord, for last 48 years, my lord, my land has been taken in Prince Anwar Shah.
Yes, Mr. Talukdar, why are you not paying compensation?
Compensation, my lord, second read.
It is their fault.
No, it's not my fault.
It is their fault.
Why?
My lord, the only issue I think.
Since they were not using the property, you have taken over that property.
Not that. Not
That is
that.
their fault.
Not that.
What is their fault?
The steps taken by these petitioners when they have started to take steps, that is to be seen. That there are facts.
Delay.
Delay is there, and they moved here and there, and then
No matter, this is second writ petition. In the first writ petition, this honorable court said, expressed concern and said that you should acquire the property. Now, what happens when the issue is very short? Well, the state what did, in spite when there is judgment of division bench, single bench of this court, saying that there is no acquisition of the land, you have to do the acquisition. Now, well, if under the acquisition of the land under 2013 Act, they have to take more. Now, what they are offering, take some compensation, and it's done. So it's not done. They have to take acquisition of the land in stamps of the earlier order. So there is no other way around. But they are lingering the matter, and all petitioners are senior citizens. 44 years, land in Anwar Shah Road, 9.
It's a fact, my lord. The earlier occasion, we took that point.
What
point? The conduct of the petitioner was to be looked. But the honorable court has.
Mr. Talukdar, you have taken.
No. We are not
taken. You have utilized the property.
That steps have been taken in terms of the order passed in the earlier writ petition. We have initiated. We have sent the proposal, and the state has acted. Compensation assessed. They were offered to accept. They are not accepting.
Why?
Where is the award?
Well, let kindly
Show me the award.
Well, let kindly come to page 41 once.
Show me the award. You cannot pay compensation without an award being declared. Show me the award.
State will satisfy that. That part is with
Now
the state. No, that is not on us. It is
but you have to pay the money.
He is the
direction.
What is the amount you have paid?
direction was upon the requiring authority to
asking you.
initiate a proposal.
Yes.
We have initiated a proposal.
Thereafter, you don't require to pay the amount.
No. We have remitted the
How much you have remitted?
Nothing. Not a
Not to you. Not to you. How much you have remitted for utilization of this property?
utilization, whatever assessment was done, we have remitted to the collector.
Who
And
is
the collector-
representing KMDA? You are led by the Honorable Advocate General in this matter? He's
Not yet.
Not yet. So he is representing the state. So he can take care of both sides.
No, he is.
When the Honorable Advocate General will be representing the KMDA, so he knows when the award was passed.
In the report filed by the affidavit filed by the state has disclosed all the steps taken.
What are the steps? I want to know. What are
They
the
were
steps?
offered to accept. The compensation amount has been assessed.
Show me the award. If you have the instruction that the compensation amount has been assessed, it cannot be without an award being passed.
I am grateful.
Show me the award that this was the awarded amount,
State
and
state
you
will
have
demonstrate
offered
that.
them, they have refused, and you have taken steps as per the Act 1 of 1894.
That's the state.
You have to
Let
take
us-
steps.
Let the
Even
state
if they do
come
not accept,
and hear this.
show me
matter.
that you have taken those steps.
State will do. State will satisfy that. We cannot. We are not the acquiring
Honorable
authority.
Advocate General will be representing KMDA.
The state to engage.
He usually represents the KMDA in the acquisition matters.
Yes, acquisition matter. Yes.
So in this matter, is likely to be.
That is why
Yes.
not yet engaged.
I
I
anticipated
cannot
this.
say that you will not
I
be engaged.
anticipated this. That is why I was asking you.
My lord, in the earlier order, there is a specific direction. The state is directed to take recourse or to acquisition of the property as per extant guidelines, and goes without saying the entire exercise should
When
be.
that order was passed?
Order was passed 2018, 6 years. And what they did? No acquisition. They say there is a kind of land policy, and in land policy,
Direct purchase policy.
direct purchase policy. What should I take? Under 2020 and 13 Act, I am supposed to get the land value plus 100%.
Their argument, our argument would lie. Here, the Honorable Court did not specify that we have to, my lord, the acquisition to be done, assessment to be made under 2013 Act.
Obvious.
Though,
Indo Development Authority,
though it was argued
constitutional bench. What is
Talukdar acquisition has to be under the relevant statute. What is the relevant statute according to you?
That lordship
Under
will
which
decide that.
acquisition has to be made? What is the relevant statute? There must be any relevant statute pursuant to which you will be acquiring.
Yes.
I'm asking you, what is the relevant statute according to you? May not be 2013.
Of course,
I accept
2013
your
Act is
submission.
prevailing. 2013 Act is prevailing. But there is also a policy of the government.
What policy?
Direct purchase policy.
Show me that if they do not accept, even then it's binding on them.
No.
Show me from the direct purchase policy.
Yes.
It's binding.
No.
Then it's your offer.
It's
merely your offer subject to their acceptance.
Purchase policy
If they
always
accept,
cannot bind the
then you may be having a policy. It's merely an offer of the government, subject to their acceptance. If they do not accept, then you have to take recourses under the relevant statute.
Here, the petitioner in 1976-77, the land was acquired for the purpose of construction of Prince Anwar Shah Road.
not acquired? Not my. Maybe
Yes,
other land.
utilized. You say utilized.
Yes.
Mr. Talukdar, there is a difference between acquired and utilized.
Their allegation is
Use the
utilized without
expression
acquisition.
utilized.
Utilized.
Unless you have something to show that
when
acquisition proceedings was followed.
But when they come up to approach this honorable court in 2017 or
You consulted the records of the land for which you initiated the proposal. What steps did you take?
we have taken, my lord, in earlier proceeding also in affidavit, I have disclosed all the documents. However, the order passed by the honorable court, my lord, since that was not appealed against, I cannot go beyond that. That's true.
My lord, only one thing, my lord. All the petitioners are senior citizen counting last days, and me and my attorney, both are, my lord, embarrassed before our client. And that is why, my lord, I understand. My lord, lordship has, there is a resolution. If lordship can, my lord, we are embarrassed before our client. Last 44 years. Any show mercy and fix the matter in any date convenient. So the matter can be heard.
Who is appearing for the state?
Chondi Charan De, Mr. Chondi Charan De, sir.
Ashun.
I'm great.
Mr. Nagla, advocate appears for the petitioner. Sir, Mr. Talukdar, learned advocate, appears for the KMDA and prays for an accommodation to assist this court on the next occasion. First up, none appears for the state. First up, as prayed for by Mr. Talukdar, learned advocate for the KMDA, list this matter on
Next Friday.
next Friday করে দিন,
Next Friday.
21st.
under the heading fixed matters.
Lordship, I am grateful. Much obliged. I won't take, my lord.
The learned advocate এই আস্তে আস্তে the learned হ্যাঁ ঠিক আছে আস্তে learned advocate on record of the petitioner is directed to communicate the next date of hearing to the non-appearing respondents.
I am grateful. Much obliged. My lord, whatever fallen from your lordship is exactly the decision I am going to cite before your lordship. I won't take 15 minutes.
Don't rely on all the observations of the court.
No, no.
Yes, next.
174. 174. My lord, I appear for the state list.
Yes. কি আছে? What is the prayer in the writ petition?
Matter is, my lord, that compassionate appointment,
Why are you not giving compassionate appointment?
that already the authority has taken a decision, the Commission of School Education. My lord, category
Rejected.
reject. That is the challenge. And my lord,
What is the ground of rejection?
round of rejection, that it was a certain dispute on
Monthly
the
income
whether-
is more.
No, not only that, but whether the petitioner applied within the time frame of 2 years, and another, for considering the financial criteria, they have taken that his elder brother is living elsewhere. But that also could not be substantiated. We have, the commissioner has found that the ground taken by the elder brother is not sustainable. On this twofold ground, that
If
was
the elder brother is residing elsewhere, he is separated
no,
from the
he has
family.
taken the gratuity, death gratuity, everything. Now is taking
That cannot be a ground for rejecting the prayer for compassionate appointment.
the family,
Taking gratuity, provident fund, that is not a ground.
but the death gratuity and everything, my lord, that's the
Is it a ground?
that the
There are decisions against this.
and another was the,
Receipt of that cannot disentitle compassionate
but
appointment.
that is only, it will, the authority has to go by the assumption and presumption, whether he's telling truth, but nothing to corroborate that living as a, that he has severed himself from the family.
You have made an inquiry in that regard,
Not
and
inquiry,
have
but
you found out that the elder brother is residing along with the family?
that commissioner
Inquiry
has,
was made.
no, that,
Then-
that much inquiry, but
Then
whether he has applied within 2 years, that is also, my lord,
not applied within 2 years.
yes, that is the thing, my lord.
Scheme says so. It has to be applied.
Yes, all, my lord, compassionate appointment has to be applied within 2 years from the date of death. But that's the thing,
When they have applied.
they have applied, my lord.
What is the period of delay?
My lord, rightly only, my lord, we have, my lord, under a concession, we have filed an opposition, although they have find that there is no direction. We will just rely on that, my lord, commissioners,
You want to file opposition?
we have
It has been affirmed.
properly, but your lordship kindly grants us leave.
None appears for the petitioner at the time of call. Mr. Dale, honored advocate, appears for the state and files the affidavit in opposition, which is taken on record. Have you served upon the petitioner?
Since there is no
Mr. Day is directed to serve a copy of the affidavit in opposition upon the learned advocate appearing for the petitioner by Monday. By Monday, list this matter under the same heading on Tuesday. ও না এ তো রিপ্লাই দেবে তো তাহলে এটা তার আগে করে দিন it will be open to the petitioner to file an affidavit in reply within ওই সোমবার হলো তো তাহলে 26 তারিখ করে দিন আর রিটার্নেবল 27 তারিখ করে দিন, 27th, under the heading hearing. Yes, next. Next.
175, 176.
176, my lord, I am for the petition in 176.
176.
176.
Yes. Yes, Mr. Chatterjee.
Lordship, this is a matter of Barn Shramik Union. Lordship, the employees, they who took the VRS. And in
State is the answering respondent.
It's the now it is railway. Earlier it was Barn Standard Company. So the PSU which had its independent existence. My lord, the recent position of that company is that it is taken over by the Indian Railway. Now, Lordship, in this situation, Lordship, Indian Railway is a party, has to be made a party. And for Barn Standard Company, Mr. Mojumdar used to appear.
Now, since it has been taken over by the Indian Railways, Mr.
Should I give it to give a notice to Mr. Majumdar as well as should I give it to Mr. Majumdar will be in a position to clear their situation. So I'll give a notice.
Mr. Chatterjee, learned advocate, appears for the petitioner. None appears for the respondents. Mr. Chatterjee submits that bond standard has been taken over by the Indian Railways. Full stop.
And Union of India is made a party. Railways is made a party here.
Railways is a party.
It's a party.
Full stop. Since the respondents are not represented, the learned advocate on record of the petitioner is directed to intimate the next date of hearing to the respondents or their learned advocates.
And if it is
this matter
already
next Thursday.
Next Thursday.
Hearing. Yes, next.
174 I'm led by Mr. Boyso. May his name be recorded. He is in 19.
যেটা আগেরটাতে মিস্টার বৈশ্যর নামটা রেকর্ড। Yes.
177.
I am appearing for the respondent. All affidavits are.
What do you want? Dismissal.
2 weeks, my lord.
Petitioners are not here.
That's why I am praying for my lord. He is not interested perhaps because one judgment already been delivered.
All right,
He is
not today.
identical matter. Keep
Not-
it after 2 weeks, my.
2 weeks.
Yes.
No adverse order today. I can record your appearance. Ashun. None appears. You are for the petitioner. Yes.
That's why I'm praying for not today.
You did not make that prayer when I was about to dismiss
But-
that. You have appeared now.
Actually, I was late.
Ashun. An accommodation has been paid for on the ground of the learned advocate for the petitioner. Mr. Gupta, learned advocate, appears for the. You are for the Union of India.
Yes, no, respondent Provident Fund Authority.
Appears for the Provident Fund authorities. First up, on the prayer of the learned advocate for the petitioner, hearing of the matter stands adjourned for the day. Yes, next.
178. 179.
After 2 weeks, my lord, kindly.
78.
79.
I am appearing on behalf of the private respondent, my lord.
Who is for the petitioner?
This matter is relating to the work. 79. Only work tribunal, he has challenged the.
Petitioner is not here. Not today, next.
179, lordship, I am appearing on behalf of the petitioner, transfer with your lordship.
I am for state respondent.
179.
Yes, your lordship.
You are for the state.
Yes, my lord.
No, early occasion, your
I am for the private respondent.
All right. Yes.
early occasion, your lordship, passed. Not affidavit exchange of affidavit not completed, your lordships. In the meantime, lordship, no stay order, your lordships. If affidavit exchange is not filed, your lordships, as per fear of the petition, your lordship.
Affidavit has been filed.
No, not yet filed, your lordship.
Yes.
Make
Work
not
of
to.
board, your lordship, direction to file the work of board and others respondent, your lordships.
Yes. Why have you not filed your opposition?
I am for make a not today. Engage senior advocate is out of registration, my
All
lord.
right. Not today. Next.
180.
এটা দিয়ে দিন, এটা দিয়ে দিন।
181, I am for the.
No, what?
মানে 180 মিলট
এই অর্ডারটা ওনাকে ফেরত দিয়ে দিন।
180 মিলট not today. Mr. Bari is leading in it.
Not today, next.
My lord, 181, my lord, I am for the petitioner. It challenges, my lord, a declaration of NPA. Other side is Punjab National Bank. In the meantime, a judgment has also been passed just a month back, which will assist this case, my lord, but today I could not bought this.
Not
Next
today.
week, my lord, if lordship. Lordship.
Declaration of NPA you are challenging in a writ petition.
Yes, because my lord, I tell you, lordship, because in terms of RBI guidelines, MSME are supposed to get one-time mandatory restructuring. That was not given to us, and that is why an NPA was declared during the COVID period. Now, when the Supreme Court has come,
There was a moratorium also during that.
moratorium that was not followed. That was not followed. I am extremely grateful. In addition to that, now Supreme Court, the law decided is that if an organization is MSME, then one-time restructuring option has to be given before classification of NPA. So that judgment I am going to cite before your lordship.
Not today, next.
I am grateful.
Lordship, 182, I am for the petitioner. My lord, this is a matter related to the food safety officer of Howrah Municipal Corporation, who was recruited by the Howrah Municipal Corporation, but not getting her salary, not proper duty and everything. Lordship, it has to be kindly fix a date, Lordship. I'll give the notice and Lordship.
Not today.
Not to be kindly, I give them the notice, let it appear.
Yes, next.
183, 184,
184 malad I apply for the state.
184 man for the petitioner.
Malad I apply for the state.
You are for the state.
State response.
Any private party is there?
Malad.
But Union of India, but the passport authority is the appropriate authority, but they have filed the affidavit of opposition.
Private respondent is there.
Private respondent is there, my lord. He never,
For the private respondent.
my lord, private respondent never appeared because he is now residing in UK.
Today it cannot be.
Yeah,
taken
that
up.
today it cannot be because the passport authority is main, my lord.
Never
But
appeared.
I have
Who is
challenged
appearing for the passport authorities? You are.
Mr. Narendra Prasad Gupta. Mr. Narendra Prasad Gupta, he filed affidavit in
All right.
opposition, my lord.
Not today,
I
next.
have filed on my report also.
185, 186,
Oi.
187,
188, my lord, subject to the leave of the court. Matter is having a lot of urgency on the.
All right.
Matter will be fixed on the next.
I will be coming at 2 p.m.
Definitely.
Not today.
Not today. Why? It is not urgent.
Sergeant, but
Or all matters are urgent excepting this.
my lord, I have missed.
Well, 190.
It's my mistake. My lord, I have missed my affidavit in reply original.
When it is called, let an order be passed. Well, I am appear for the response.
Come at 2 p.m.
ওর অসুবিধা কি আছে 3 মাস একজন করো
অসুবিধা হচ্ছে
রিকোয়েস্ট
Your Lordship, may I permit to mention one matter for inclusion, Your Lordship?
Not now. Yes.
Yes, Your Lordship.
185, 186, 187.
Honorable Uncle of the petitioner, my lord.
187.
Yes, my lord. Mr. Biswajit for the state respondents. Mr. Biswajit for the state respondents, my lord.
Where is he?
No, I have some notice, my lord.
You have served notice, but not
No,
today.
matters, my lord, related to my lord, higher scale of pay I am getting.
Higher scale of pay.
I am getting 2009, but it should be from the date of appointment, 18/1/2021. Only that, my lord, I have annexed the similar judgment, my lord, last annexure.
Bring the other side. Not today.
188.
But subject to the leave of the court. I am for the writ petitioner. But my other side is not available. In that event, my humble prayer before the Lordship. On the next day, let this matter be kept within 1 to 5 items, Milord.
1 to 5?
Because, Milord, kindly consider, as
75
I am a
years old.
senior citizen and right now I am suffering from the cancer, I do not have a money for my treatment. Lordship, kindly consider this.
Who is appealing for the respondent?
Mr. Mujumdar is appealing.
R.N. Majumdar.
Mr. Mujumdar means? Which Mujumdar?
Mr. R.N. Majumdar. I have served the notice upon him also.
I can pass it over. Has he come today?
But I do not have any notice.
If he has come,
Very
I'm
well.
passing it over.
Very
Yes.
well, Milord.
Next.
9, 90,
190. Din.
My lord, I appear for the petitioner in this matter, my lord. My lord, I have missed the original affidavit in reply and
I'm seeking your lordship's leave to file the affidavit in opposition on behalf of the respondent numbers 1 and 2.
What is this
This is
matter?
concerning, my lord,
my lord,
fairness allowance.
my lord, we have sought implementation of ROPA 2020 to the extent of not granting, my lord, DA at the rate of central government. We have prayed for quashing 2 clauses.
Who are you?
Well, I am the corporation, West Bengal Power Development Corporation.
Power Development Corporation. Why are you not paying?
Now we are
What is your
paying.
stand?
In terms of, my lord, the ROPA 2020, whatever we have promulgated, we are paying. We are paying and they are accepting. The pay slips are appended to the affidavit in opposition. It would appear therefrom that we have been paying and they have, without any demur, they have accepted it. And they are seeking to, unnerve a situation, all throughout from 2009 till today. Whatever is the dearness allowance, not fixed by the state but by the corporation, we are paying it. And they have all accepted it. As on date, it is definitely more than 10% of what the state government
Citizens will be one of your grounds.
They are
delay also.
I won't say delay. They are taking a chance. If they can persuade your lordship, then maybe they may get some extra benefit. But according
persuade you.
Huh?
They could not persuade you.
Persuade my employee. Their employer, they could not persuade. Me, tomorrow I may appear for them. I am a creature of instruction.
Yes. If they can persuade your client will be persuaded through you.
And Mr. Siddiqui has to be persuaded, not me.
My lord, in ROPA 2009, there was specifical, my lord, service condition was laid down with respect to DA pertaining to central government rate. Whereas in 2020, it has been made opaque, and my lord, it has been entirely left to the discretion of the management.
She knows the man. I'll give her my brief. Let her argue. Mr. Mujumdar
No,
is
I
reading.
don't have the affidavit in reply, my lord, original. My lord, I have
a copy.
Court's copy has to be filed.
Yes, my lord, notes.
Original is lying with her.
I cannot tell her anything.
Was 7 and 28 of ROPA 2020.
Yes, my lord.
So
there are other prayers also, my lord. We have also sought for, my lord, adequate
so that is
operation.
the deprivation. That is the deprivation that Those clauses state that he will not be entitled to at the central government rate.
Lordship. And also, my lord, adequate operation and maintenance
Where
allowance
is
is
that
not being.
clause? Yes, Mr. Vadaji, where is that clause?
ROPA 2020.
7 and 28 of ROPA 2020.
First, your lordship sees page 47. Please come to page 50. This was prevalent in 2009.
They have prayed for setting aside clause 7.
I'll come to that. First
Page
is, Milord,
50. Yes.
Please see clause 9.
Yes, 9.
Henceforth, dearness allowance, has my lord got it very kind?
Yes.
Will be applicable to the employees of the company at such rate and from such date as may be notified by the central government from time to time. This was, my lord, in 2009. Now, my lord, please come to.
This was in
2009. Now, my lord, please come to 106.
This is 2020.
This is 2009. The one I invited,
Yes,
my
yes.
lord.
106 is 2020.
Yes. Please come to 110, clause 7. Rather, my lord, 111 before clause 8. নোট করি না জানি যেখানে আসি কোথাও না কোথাও থাকবে আর কোথাও না কোথাও থাকবে
Oh, initially it was as may be notified by
now
central government. Now it's the
yes.
state and the center.
Yes. So
you will be taking the benefit of either of the. Which one is less?
Whatever. In any event, we are paying higher than the state, right? We are always
Will
paying.
be decided by the company, my lord. This is our,
Yes,
my lord, second line.
I believe করছি না জজ সাহেব প্রশ্ন করছে ভাই I am not Mr. Siddiqui says কেন ওকে I am not saying anything.
Yes.
Definitely Mr. Mujumdar will argue.
And 20, where is clause 20? No, sorry, 27 and 28.
28, my lord.
Where is 28?
27 and 28 is 117. Special allowance. They are concerned with O&M allowance.
Yes.
They are concerned with 118.
Who are not entitled to overtime allowance but required to work beyond will get O&M allowance per head per month. So this is instead of overtime O&M allowance.
Yes.
But they say they are entitled to overtime allowance.
Yes.
This is what they are trying to canvas.
And my lord, adequate operation and maintenance allowance.
Are they challenging any decision? No.
No, these are the decisions.
No, this is the
circular. Or rather,
circular.
This is the decision communicated. And apropos this decision, they have exercised their options. They have merely agreed to switch over to the revised scale of pay.
So according to you,
there's a form of option.
Once they have exercised the option,
yes.
So they cannot pick and choose.
They cannot.
They cannot say that I will give me other clauses,
yes.
But these clauses I am affected.
Yes. Now, please
either
see.
They have to accept or reject as a whole.
Please see page 128.
Yes.
বিশ্বাস নেই ভাই আমার একটা গ্রুপ
So if, Mr. Vadaji, if they do not exercise this option, then
they can't come over to the high the revised scale.
So
please see clause 5 first. Then I invite your lordship first to clause 5b, 5.5, 5.5, page 108. দানা বাবা দানা 2 মিনিট দানা তারা তো 2 মিনিট বাদেই কন্টেম্প রুল জেলে আমাকে ছেড়ে চলে যাস না
Clause 5.
My lord, note 1.
Yes.
An employee may have option to get his or her pay fixed either from the date of promotion or from the date of next increment.
Yes.
এখন জজ সাহেব প্রশ্ন করছে দাদা আমি করিনি মামলা Mr. Mujumdar is here. He will lead me in another matter. Let us both go. Let us both go.
Missed the brief.
Yes.
But not, this is really not the
চলো না,
2 or
ওইখানে চলো
3
না, তুমি
issues.
এখন করবে কেন? তুমি আমারটা চলে this is the form of option. This is the option, and in terms of this, Milord, page 128 of the writ petition.
They have to exercise that option.
Yes, and having
According to
exercised,
you,
yes,
either they have to accept as a whole or not at all.
and having exercised that option, according to us,
Cannot challenge some of the clauses.
without demur, they have exercised the option. That is not without prejudice to anything. They have
That
accepted.
could not also have been done. Because once they have to accept, either they have to challenge.
One way of looking at the issue is, these options are all standard form options. I am arguing against my client.
Yes.
And I am saying, assuming, that there is a form where you don't have an option apart from signing. That can be also argued by them. Of course, my senior knows what is to be argued. But
There are 3 issues to be addressed. This arises out of a ROPA for the distribution company limited. But first part is whether an officer who is rendering more than 48 hours of duty in a week in relation to a premises of a factory is entitled to overtime duties. So this is something which is governed by a statute, cannot be governed by ROPA. ROPA being a rule.
So according to you, instead of that O&M allowance, you have to be given overtime allowance.
3 things. One is, apart from this administrative order, there is a special provision statute governing the field.
That will prevail.
Number 2, to that they have taken up an objection that Factories Act, the meaning of the word employee as employed in the Factories Act must be construed as workman category alone. To that I have a different submission which I shall advance. Second point is,
according to you, this power development is governed, or the Factories Act applies to this?
Every factory in the country is to be governed by the Factories Act. Now, second point is that allowances, whether that can compensate the statutory liability. Third, in the office of a factory, employees have certain conditions of service which is not being rendered to those who are on the floor of the factory. And those who are working on the floor of the factory are put to a lesser position vis-a-vis their leave entitlement and encashment thereof.
Mr. Mujumdar, what was the earlier ROPA?
Similar provisions. Similar provisions.
So, similar provisions in the earlier ROPA,
which were being objected to, asked to be taken note of in the subsequent ROPA.
But if you have accepted those similar type of allowances or perquisites in the earlier ROPA, can you now question on the similar ground?
Custom or usage which is beneficial cannot be withdrawn. This will not debar a person.
Earlier you were getting a better benefit.
I was getting similar types.
Yes.
When we came to know of this, that other officers were getting more. They were having a better service condition. We immediately objected to that and we wanted revision of that ROPA. Through the course of deliberation, this ROPA came and we still found that those grievances had not been addressed to.
This ROPA, there is an expert body who forms this, or the corporation itself?
No, it's not like the other ROPAs.
Yes. Now here the corporation corporation frames this. There is no expert body.
Not expert body as such, as it appears from the preamble to the ROPA.
Please see page 103. 103. এটাই তো বলছো তুমি।
Yes, 103.
No. This is the preamble.
It's more of a demand and consideration. Please see paragraph 3. The working group has submitted its final recommendation on the revision of pay and allowances, and the board of
Approve the recommendation.
working group. There is a working group.
Yes.
Working group constituted by the management.
It must be having the employees representatives as well.
I don't think so.
Working group,
Don't think so.
no representatives.
Because if your lordship please come to paragraph 4, the
Yes.
working group had held several rounds of discussion and considered all the representations made by the unions association.
So according to you, this group is distinct from the union and the other associations. So those representations were considered, and this is the ultimate recommendation.
So it's the rule framed by the board.
So in your representation, those points were taken.
All these points.
So your grievance is that those were not implemented. When do you want?
A custom or privilege which is beneficial can continue and cannot be withdrawn, but a benefit which I am demanding but has not been redressed will not be stopped by ROPA.
When do you want?
No, next week.
When do you want?
Next week, no, next week if it's so pleasant.
Next week.
No.
Now, my lord, your lordship will be taking matters singly. We all hope.
Yes, Mr. Bhattacharya.
Mr. Bhattacharya. Thursday or Friday, my lord.
Next Thursday.
No, Monday, এই সপ্তাহে
আসুন।
থাক না, শুরু করুন একদিন তো শেষ আছে।
Heard Mr. Mojumdar, learned senior advocate for the petitioner, and Mr. Bhattacharya, learned advocate, representing the respondent corporation. Corporation is the only respondent.
I'll just check it. Perhaps yes. Yes. No. Yes. No. State is also there. State is also there.
But
State.
State will not be considered.
As jointly paid by the learned councils for the respective parties, list this matter next Thursday date under the heading hearing.
Jointly paid, court's order. Jointly, it becomes very.
Why? I've taken consent of both of yours. Your availability.
I have no objection. I have no objection.
Always.
As jointly paid na kore, list this matter kore.
21 তারিখ রাখবেন কি? চলো।
Oh, affidavit in opposition filed by the respondent numbers 1 and 2 is taken on record. Mr. Mojumdar, you will be filing a reply on the.
I have served a copy. Yes, I shall be filing.
The petitioner is directed to file the affidavit in reply on the next date. Service.
I have effectively served. Yes.
বলেছে তো বটেই, দাঁড়ানো দেখে নি।
Reply the next date. Opposition. Your advocate on record has not given the copy to you.
I think he has.
Pay cost and then take copy from him.
That may not. I will.
That Mr. Mojumdar cannot now commit. His status has changed. Now you
Mr.
have to convince
Mojumdar,
the
your
advocate on
lordship does
record.
not.
Now you have to convince the advocate on
I
record.
will go to room number, that building. I will go to his office, collect.
Yes, next.
Great. Your lordship is kind enough to keep it, Mila.
Next Thursday.
21st.
191.
Not a vector pay for the petitioner.
Today,
No, my lord. On the last occasion, the state respondents were to file their opposition, my lord. The matter relates to recruitment of Asha Kurmis, my lord.
what do you want?
But the state respondents were required to file their opposition, my lord. They have still not
They have
filed.
not filed.
No, my lord.
Already not today, next.
But let a date be fixed, my lord, at least.
Monday.
192, 122 lordship, I appear for the petitioner. My lord, reply opposition is completed. Come back next week. 193.
My lord, I appear for the respondent number 234. This is a change brief. So
all the respondents are here.
I don't think so. State is not.
Any other respondent? They can file this.
The state is
respondent number 1.
Who is representing the state?
I beseech your lordship's kind permission to file the affidavit for 1 week. My lord. This is a change brief. So, my lord, the earlier set of lawyers, they didn't file any. And we are the main concerned respondent.
What is the issue?
Issue tender. We have cancelled the tender on administrative reasons, and they have challenged that cancellation.
You have floated a fresh tender? No.
No. There is an injunction order.
There was an injunction.
Since 2023.
What was the subject matter of tender?
My lord, setting up of, my lord, way bridges near, my lord, the borders of, my lord, the states to control, my lord, the weights of the trucks carrying goods either in or out of the state. That was done, my lord. It was, my lord, the requirement was that I shall have sufficient land as per the specification. That was done. First tender, possibly in March, my lord, technical bid was opened and immediately thereafter it was cancelled. I did not raise any dispute. Thereafter, they, my lord, had floated a second tender. In the second tender, the technical bid was opened. I was qualified. Then, my lord, the financial bid was there. After that, they suddenly say, sorry, tender cancelled. Now, we have several points.
You are challenging the second tender?
Yes, first I did not.
Second tender, so you are challenging any decision of the authority?
Yes.
Where is that?
The cancellation matter.
Where is that?
I learned. Because my brief, my lord, my man, my lord, said that, well, you said that so many matters, it's so down, you are not required to take the brief. I don't remember, but I have to rely.
But
116, 116. Sure. এটা তো corrigenda.
116 is a corrigenda.
No,
It has been cancelled due to administrative reasons.
Kindly give me a minute's time.
This is the impugned order due to administrative reasons.
Yes. Yes. Now, the interim order was passed long back. It was passed on 9th of June 2023. Direction was given.
Up to 31st March, it is there.
Yeah, interim order is there. It has been
order is there.
It has been extended from time
What was
to
the interim order?
Not to, my
Not
lord,
to float any fresh tender, my lord.
shall be restrained by an order of injunction from issuing a further fresh tender for the same work as covered by the tender, which was cancelled by the impugned decision. Order of 9 June 2023.
So by affidavit, how you will improve?
My lord,
you give additional reasons to support your cancellation by way of an affidavit.
yes, my lord, that everything is to be disclosed, including, my lord, the
what you will disclose?
locus standi of the petitioner, my lord. When the tender was floated, my lord, he participated.
No,
Mere participation will not give him entitlement to challenge the cancellation of the tender. It was the decision.
So that is the point of law which can be decided.
My lord.
Participation, I don't think Mr. Mitso is disputing that he has
But your lordship.
So that is why he cannot also dispute. So for that, you need not file any opposition.
My lord, your
The
lordships can
cancellation in
appreciate
one
the.
line, you also cannot improve by giving additional reasons in
My lord,
support
that's
of
true,
the
my lord, but your
cancellation.
lordships kindly
So
appreciate.
how will you improve by filing
My
of
lord,
an
your
affidavit?
lordship kindly appreciate the predicament. There was an order of my lord filing opposition, and my lord,
I appreciate that.
for good or bad, my lord, it was not filed, and my lord, the department.
No. I appreciate that time also can be extended. I'm asking you what is the reason? What for you want to file an affidavit
My
in
lord, day
opposition?
before yesterday, it was my lord handed over to us, my lord, to defend.
Because he's challenging that order of cancellation. So whether he has a right to
Yes,
pray that
yes.
you are bound to carry on
Yes,
with the
yes.
tender or
Whether-
not, that is the point of
My
law
lord,
which
that is
can
the
be
point.
decided.
That is
I
the
don't think for that any affidavit is necessary.
But my lord, for our protection, my lord, we have to.
And if you say no, some documents you want to rely upon,
My lord, that
it was before the tender inviting authority or the committee
at the
concerned.
moment, my lord, I cannot say, but it is under process. 1 week will do. Your lordship kindly fix it the next week. Huh?
So interim order is till March.
My lord, till March.
31st March.
So I'm extending the time to file opposition by a week.
Grateful, your lordship.
As paid for by Mr. Roy Larned, advocate appearing for the which respondent?
My lord, 2, 3, and 4.
By the respondent numbers 2, 3, and 4. Time to file affidavit in opposition is extended by a week from date. Reply thereto, if any, be filed within 1 week. Within a week thereafter.
I'm sorry, Malak. No, he was suggesting a shorter time.
Shorter time?
Yes.
3 days?
দেখো ভাই তারপরে সময় চাইতে এসো কাইন্ডলি গিভ 7 days টাইম
week 1 week 1 week 2 weeks ঠিক আছে
Grateful, your lordship.
opposition 1 week reply 1 week after 2 weeks yes
can it my lord retain my lord today is on a different head under a different head but
Mr. Mitro, continuing matters, if it is hard, then I'm keeping it under the heading either fixed matters or if it is hard substantially.
I was requested to make the submission. I have done.
Grateful, your lordship.
Yes.
194. My lord, 194. I am for the respondent, my lord. For Union of
Respondent?
India. Yes, my lord. My lord, I have
the
submitted
petitioner.
affidavit with opposition, my lord.
Keep it with the petitioner is not here, not today, next.
File the affidavit already served other side.
Keep it with you, file on the next day. Yes, next.
Yes,
195.
Yes, my lord, I'm praying for not to my lord.
Lordship, in 195, I'm appearing for the Public Service Commission. In this matter, the Honorable Judge has asked the Public Service Commission to file a report, Lordship.
Yes.
Public Service Commission was initially not a party, Lordship, in this matter. This matter was
So,
in.
You have filed, the affidavit report is ready.
Report is ready. May I
Want to
file my
the
report?
report?
Yes, Lordship.
Yes, my lord. I'm praying for not today, my lord.
She's filing the report.
Yes, my lord.
Have you got a copy of that report?
Lordship,
No,
this
no.
is only between court and PSC, Lordship, because this has nothing to do with the petitioner, Lordship. The matter,
देखिए तो file टा दिन.
I have not received the copy, my lord.
Lordship, this is only between the PSC and the court, I believe, Lordship. This is internal documents, Lordship, I'm filing.
देखिए order टा देखिए आगे.
If the petitioners are the supervisors of self-help groups and they have made a representation for absorption in the permanent service, Lordship, the Honorable Court directed the chairman of Public Service Commission to file a report
Yes.
on the number of requests received from the state in last 10 years for filling up the post in any department, Lordship. And the PSC shall have been asked to indicate the normal time and process specified under the rules taken to complete such recruitment process. It's a general direction given on the Chairman Public Service Commission.
To the petitioner in.
Yes, Lordship. That's why, Lordship, I have been instructed, Lordship, it's only between the court and the.
By which
Honorable
order
Justice.
it was directed.
It was directed by 7th March 2024, Lordship. Initially, I have filed an interim report, Lordship, and thereafter, this is the final report I am filing, Lordship.
Honorable Justice Rajasekar Manta directed to
filed the report.
Report as directed by this court by order dated 9th of May 2024.
There was two orders, 7th March 2024 and 9th, my lordship.
7th of March 2024 and 9th of May 2024, filed by the Chairman, Public Service Commission, West Bengal, dated 28th of May 2024, is taken on record. First up, on the prayer of the learned advocate for the petitioner, hearing of the matter stands adjourned for
next week.
For a week. Next.
Grateful, my lord. ওই advocacy record যে আছে
Grateful, my lord.
196.
Example, the respondent as in this matter, Mr. Learned Advocate Onimus Paul is appearing in this matter.
Is appearing?
Learned Advocate Mr. Onimus Paul is appearing in this matter. I'm for not to lordship. Lordship.
Well, personal ground, I cannot object. My lord, difficulty is, my lord, it's a police inaction matter. There is a, my lord, a decree in my favor, permanent injunction, my lord, against, my lord, the private respondent, my lord. Even then, my lord, I'm not in a position to go to my nearby to my.
Execute the degree of permanent injunction. Why have we applied for police inaction? There is a provision for execution.
But my
lord, the Code of Civil
Yes,
Procedure.
yes,
Execute the degree.
That is there, but that is there. But the difficulty is, my lord, that will take time.
What will take time?
My lord, for execution, that will also take time. My lord, I have, my lord, immediately after getting the decree.
So that is the ground for approaching the writ court.
Not that. But alternate remedy is there, my lord. I appreciate. But the difficulty is, my lord, even, my lord, the police, when the order was passed initially, there is an interim order. Even then,
there is an alternative and efficacious remedy. It's the discretion of the court whether to entertain or not.
Yes, that is there. So, that is there. But my lord, when the interim order was there, that was communicated.
Now it's coming for final hearing.
No, the lordship is of course, my lord, suggesting for execution. Now, my lord, we are getting an idea how the order can be executed. It has to be executed through police. Now, what police is saying? Go there, I am there. Police is there. We are going there. Police goes. We are ousted. Tomorrow it is going to be executed. Definitely, police cost will be paid. For how many days? For how many? That is the difficulty, my lord.
So what order you expect from the writ court?
Well, at least, my lord, something.
What something? Say specifically.
At least, my lord,
how that should be executed. Day-to-day vigil.
Yes.
Police posting.
No, that is not
approach. Under the relevant provisions.
That is
for police posting.
Police posting, my lord, will bear cost.
Yes.
Will bear, my lord, how many days, my lord, the petitioner, my lord, will continue?
You are saying cannot be executed through the civil court. So writ court, what order can be passed according to you? On a particular date, police is going.
My lord, even my lord, when police was there.
What is the property? It's a vacant land.
Vacant land, my lord. My temporary structure is there. I want to have my house, my lord, permanently, my lord. That is not being possible, my lord. We have placed the entire.
What are trying to do?
My lord, the moment, my lord, we are trying to, my lord, circle the land by fencing, they come and remove it. That is the difficulty, my lord, we are facing.
That is the difficulty before the writ court.
Yes, my lord, I know, my lord, I know, my lord, some solution has to come.
Can the police be directed to give protection at the time of fencing?
Yes, if the police gives direction, if police is directed, if my lord,
can the police decide on the boundary line of a property?
No, not boundary line, not boundary line. My lord, they are nobody. It is not that they are residing nearby, so there is a boundary dispute. It is our land. Then Amin can be, my lord, appointed to determine.
That cannot be in a writ petition.
That is not the writ petition.
Whatever. If there is a dispute, appoint and approach the authorities under the.
That is not, my lord, what I am on, my lord. When, my lord, police, my lord, in the implementation of the interim order of the court, be there, and when even, my lord, leaving the place, my lord, if this thing happens repeatedly, my lord, then police, my lord, be, my lord, directed to take immediate step against those persons who are, my lord, violating even the police order. If once police books them, my lord, something will happen. That is not being done. Police,
What police will do?
police, my lord, to register a criminal case against them, my lord.
Have you lodged a complaint?
Yes.
Disclosing a cognizable offense. Show me that you have lodged a complaint, disclosing a cognizable offense. I am directing the police to act on the basis of that complaint.
My lord, through learned advocate, that is done.
Yes. So I can direct the police to take action on the basis of that complaint. If a cognizable offense is disclosed, police will register a FIR.
Well, let my learned friend come, my lord, next occasion, my lord, then I will place it.
That order, I think, can be passed even today.
Yes. Then, yes, then Lordship kindly.
Can you make it a not today?
Yes, that can,
and fix
Lordship
another
kindly
date
come
and
to
that didn't matter.
page
You heard and
35.
date
All right,
never-
all right.
Page 35.
That's it.
All right,
Grateful,
not today.
Lordship.
Next.
197. 198.
So your lordship 197. Your lordship, I pray for not today.
Not today.
198.
198. I am for the petitioner. 198. There is a direction, my lord, for filing affidavit by the respondent, but
who is the respondent?
Respondent is the correct. The director of Special Audit Unit, Special Secretary, P and RD Department, Mission Director. The issue
who is appearing for them?
Appearing for them on 5th July, there is a direction for filing.
Who is appearing for them?
Miss Iti Dotto.
Led by Mr. Supriya Chattopadhyay.
Yes.
Inform them. Not today.
Yes, yes.
Yes, next.
199.
199. I am for the petitioner, similar to 148. The pensionary benefit has been 3% increment for additional responsibility.
3% additional increment.
148.
Who is representing the state?
My lord, Mr. Arindam Chattopadhyay is appearing for the state.
Sir?
Mr. Arindam Chattopadhyay is appearing for
Where
the
is he?
My lord, due to personal difficulty, he has
Not come.
I want my lord, I will prepare a compilation. You will also fix this date, my lord, along with my lord 148. Wednesday.
Wednesday. Under what heading? It was fixed. 148. 148 টা দেখেন fixed matter এ করে দিন 148.
Yes. 148
এর যেরকম হ্যাঁ
that's all matters, my lord, similarly that has been
আচ্ছা
upheld.
করে দিন Mr. Jana Laner advocate appearing for the petitioner submits that the issue involved in this writ petition is more or less identical with the issue involved in 148 এর WPA নাম্বারটা কত বলুন? WPA 2115 of 2024. First up, in view thereof, list this matter on under the heading fixed matters.
200 also same.
200 also at order record করে দিন, same order. একই দিনে fix করে দিন. Yes, next.
101.
I am appearing for the petitioner. Now, it's a tender matter. State is the answering respondent. Now,
What happened?
My father expired on 28th of January.
Yes.
Well, if it is possible, my lord, let it appear under the heading upgraded matter. My lord, it's a short matter, my lord. If it is taken up,
Upgraded matter, if it is not substantially hard, I am not.
Kindly make it not today.
Let it appear thereafter. Next.
202.
My lord, 202, my lord, I am appearing for the petitioner, my lord, in this
Petitioner?
Petitioner, my lord. But there was
Bandyopadhyay for?
My lord, there was a direction for affidavit in this matter last year.
Sorry, Bandyopadhyay is appearing for the private respondent in 201. What? No, it's a the state is the answering respondent. My learned senior friend is supporting the state action. So,
affidavits you have filed?
Yes.
So matter is ready.
Ready for hearing.
Next day.
Yes.
My lord, there was a direction for affidavit in this matter. My lord, affidavits have been exchanged. My lord, the answering respondent is the state as well as the bank. My lord, bank has not yet filed any affidavit. My lord,
What is the matter about?
my lord, banking fraud, my lord, 9.5 lakh was withdrawn from the account of the petitioner by making a loan which the petitioner had never applied. All were withdrawn after 7:30 p.m. Every day.
And on 4 occasions, my lord, 9.5 lakh was withdrawn, and it was, my lord, credited that you have taken the loan. It is your responsibility. Now you pay back. Now, my lord, when the petitioner updated the passbook, the petitioner found that on those days he was not even in his native place. He was in Tarapit. My lord, subsequently, my lord, the petitioner lodged an FIR. If an FIR was lodged, my lord, investigation started. My lord, on several occasions, my lord, on all the occasions, in fact, my lord, the police on all occasions, my lord, submitted FRM before the court, saying that no. But my lord, from the affidavit filed by the state, my lord, it would be evident, my lord, that a particular loan on the same date was credited to the bank account of the petitioner. And after half an hour, subsequently, the matter was the amount was debited.
Who is appearing for the bank?
My lord, for the bank, that was the last order. But it was, I don't have the copy, my lord, last order, my lord. 6 years, my lord, charge sheet have not been filed. Investigation,
Respondent number 7 and 8 is the bank.
Bank.
Nipesh Maji.
Yes.
And Sudipto Panda for the state.
Sudipto Panda, my lord, had filed their opposition. My lord, I have prepared the reply. My lord, any short date, because the court below, my lord, there the matter is pending. My lord, the court below is saying that no, High Court, since it is pending before the High Court, I will not proceed.
There is no order of stay.
They are not proceeding.
No, what is not proceeding? Charge has not been framed.
Charge has not been framed. Every time, my lord, the police authority is submitting the FRM, my lord, till date, no investigation at all proceeded. My lord, I filed this writ application saying for the change of agency of the investigation. But, my lord, from the affidavit of the state, it would be relevant, my lord. Absolute fraud had been done on that.
All right. I'm making it not today, next day.
My lord, any short date, my lord, subject to convenience of this court. My lord,
next week it will appear.
My lord, great. But may I serve a notice to the?
Yes, yes.
My lord, right.
Let it appear on the next day. Let it appear. Let it appear. Yes.
Good.